close. I still prefer when you guys are back on the sides. It's like, you're just too close. It's too much. Okay, so good afternoon. Welcome to the Appellate Division First Department. We are hearing oral arguments today. Obviously, I will be calling the calendar in a few seconds. You know the spiel. Please only ask for the time that you actually need and not the time that you would want in a real world. So we've read your briefs. We are familiar with your arguments. So it says 6 hours of argument requested. So that would be 8 o'clock. So, relax, sit back, right? Not happening. Martinez versus the City of New York.
Appellant request 8 and 2.
Respond in 10 minutes, please.
828. People versus Rafael Davalos.
Appellant request 6 and 2.
Respondent request 5.
525. Hess versus EDR Assets.
Appellant request 8 and 2.
624. Marstella versus the City of New York.
Appellant request 8 and 2.
Respondent request
525. D. Children is submitted. Napolitano versus 536 9th LLC.
Appellant requests 5 and 2.
No respondent. Did you still wish to argue?
We'll submit.
Thank you. Submitted. People versus Anthony Jolly.
Appellant request 5 and 1.
4, 1, and 3. Justice Pitt is recused on that matter. Cresco Labs, New York versus Fiorello Pharmaceuticals.
Appellant request 8 and 3. Cresco respond request 10.
Oh, okay. 525. Rivera versus Mattis Architecture. No pressure. No pressure. No pressure. It's up to you. 313. Tavares versus LIC Development.
Appellant request 5 and 2. Respondent request 5.
5, 2, and 5.
Thank you.
People versus Joseph Montesquieu.
Appellant request 4 and 1.
414. Winston Salem versus Ladder Capital.
Appellant request
3 and 2. 324. Reeves versus Associated Newspapers.
Appellant request 8 and 3.
And Your Honors, Robert Balin Davis, Wright Tremaine, member of the Bar of Support. I'm introducing Kelly Sager, member of the California Bar.
California. You came all the way from California?
Actually, I did, Your Honor.
Oh, okay.
For this beautiful courtroom, it's worth it.
Isn't it? It's worth the trip. Yes, yes. 626. People versus Joshua L. That matter is submitted. Paulson v. Paulson.
8 and 2 for appellant, please.
Respondent
828. Rothstein versus Permanent Mission. That matter is submitted. First matter for argument is Martinez versus the City of New York. And please, attorneys, just keep in mind, although the time was allotted, if we need additional time, because there are additional questions that have to be asked, we will certainly do so, okay? Whenever you're ready.
Good afternoon, Your Honors. May it please the Court. Amy McCamphill on behalf of the appellant, the City of New York. Your Honors, there are multiple reasons why a Supreme Court's order should be reversed. And I'd like to start by talking about the merits, because on the merits, Supreme Court...
I just want to be clear. This was a motion for a preliminary injunction. Is that correct?
The motion that the plaintiffs filed was for a preliminary injunction, yes.
And so a number of these issues had not been briefed. Is that correct?
The merits were briefed only in the context of the preliminary injunction motion, yes, Your Honor. The city only submitted a motion in opposition to the preliminary injunction motion. There was no predicate for conversion to a summary judgment under CPLR 3211C because the city never filed a motion to dismiss. And the court converted the plaintiff's motion for a preliminary
You made
injunction.
the argument that you made a cross motion to dismiss, right?
And there was no cross motion to dismiss, Your Honor. The
I'm
city,
just telling what they said.
yes, there was a reference in the city's motion in opposition to the preliminary injunction. There was a reference to a accompanying motion to dismiss, but that was an error. There was no notice of motion ever filed, and the city never moved to dismiss. So there was no predicate for conversion.
So there was a reference to a motion, but there was no actual motion that was to be considered, nor an actual motion that was before the court.
That's correct, Your Honor. And at the oral argument, if you look at the transcript, the city clarified that that reference was in error.
And even so, I mean, the substantive issues weren't really addressed or briefed, right? I mean, even so, if that were the case, where we're going to go with the arguments, correct?
Again, the merits were only addressed in the context of the preliminary injunction.
Right.
So there was no basis to issue a final decision on the merits. Moreover, the court didn't provide notice to the city before converting it to a summary judgment disposition as required by.
Well, that was my other question. Was there any notice to the parties that the court was considering or was going to convert to a motion for summary judgment, and therefore those issues should be briefed?
The plaintiffs had requested that the court treat the city's opposition as a cross motion to dismiss based on those errant references, but the court never provided notice until at the oral argument. Then the court told the parties it was interested in proceeding that way. With the court's scheduled oral argument and the docket notice didn't say anything about proceeding to summary judgment disposition. So the city had no notice from the court that the court was going to proceed in that way. So procedurally, the court's order was incorrect. And on the merits, the court's order was plainly incorrect. And there's three main reasons here, Your Honors, why it was incorrect. First, the court said that Local Law 15 was not intended to apply to persons whose convictions were prior to the law's enactment, when by the plain language of the law, it applies to persons who have been convicted.
Right. She's talking about, the Supreme Court below was talking about retroactivity. There's really no retroactivity at play here, right?
Sure, Your Honor. Exactly. So the law does apply to persons who are convicted prior to its enactment, but that doesn't make it retroactive. And we know that because there's two Court of Appeals cases directly on point. The Leon St. Clair Nation case.
It's a qualification. It's merely a qualification to be a candidate. You have to satisfy A, B, C, D, and E happens to be you're not convicted of a crime in where you committed fraud or whatever in public money, basically, right?
Yes, Your Honor. It's a qualification going forward.
But does that matter in terms of, maybe this would have affected how someone negotiated a certain outcome in any criminal case that would have resulted in this now thing that disqualifies them? Does it matter that we could look at that as retroactive?
Well, it was the same issue in the Leon St. Clair and the Miller versus DeBono case. The parties in those cases argued that they wouldn't have known at the time of their prior misconduct that it would have these ramifications for future qualification. And the Court of Appeals said twice that basing qualifications prospectively on past conduct is not retroactive. And third, Your Honors, even if it was retroactive, and this is the third way the Supreme Court erred, even if this was considered a retroactive law, the standard for substantive due process for retroactivity is simply whether it has a rational basis. And Supreme Court wrongly assumed that any retroactivity would be unconstitutional. But all you need is a rational basis. And here this law serves compelling city interests.
Was there anything, I'm sorry, go ahead.
Getting to the interest served by this law, is it significant that some of the laws, some similar laws that set criteria or for running for office set time limits as to when a person can run after a certain kind of conviction, and this one does not? Does that affect the public policy, the validity of the public policy underlying it?
So some other laws do and some other laws don't. If you look at the State Public Officers Law Section 3(1)A, there's two subsections, Roman numeral 1, Roman numeral 2. Roman numeral 2 has time limits on disqualification. Roman numeral 1 does not. Plaintiffs studiously ignore that subsection, and that's longstanding provision of state law. City Charter, Section 1116, also doesn't have a time limit on disqualification, and that's another longstanding provision of law that disqualifies people from holding offices who have been found to have committed certain acts
Well, I mean, that was going to be one of my questions, is there any significance to be attached to the fact that we're talking about using public funds and now you're running for public office? I mean, there is any significance in terms of the two?
It serves compelling anti-corruption interest because it ensures that people who have been found guilty of committing public corruption and fraud do not serve in high public office where they have the opportunity to commit more public corruption and fraud to the detriment of the public. And those are the same public interests served by Public Officers Law, Section 31A and City Charter 1116, and through the same rational means, by disqualifying certain people from holding certain offices.
And it's part of the,
Go ahead.
it's part of the rationale that this is a kind of crime that they can only do if they're elected to office. So if you don't allow them to be elected to office, they can't engage in this particular crime that they've done before.
I don't think that's true of all of the disqualifying crimes in Local Law 15, but all the crimes in Local Law 15, they're all focused on fraud and corruption, and those are all crimes that the City Council was found particularly worthy of barring people from holding offices if they have been convicted of such crimes, because then they have the opportunity, again, to use public money for their own benefit.
So in terms of Local Law 15, was there any legal analysis conducted by the court? Or what was the legal analysis conducted by the court as to why it found it to be unconstitutional?
It is a bit of a mystery, Your Honor, because the court just says it's retroactive and then struck down the law to the extent that it is retroactive.
Right. I didn't see any real legal analysis or any basis for the decision, I guess is what I'm saying. So I was wondering whether there was something that I was missing, whether something was stated during oral arguments or somewhere else that would lead us to
If you look
figure out exactly what the rationale was.
the hearing transcript, the court makes statements that are very similar to what is in the order. There's no more illumination to the court's reasoning. And because, again, the law is not retroactive, and even if it was retroactive, it has a rational basis, Supreme Court's order is just wrong on the merits. And for that reason, it needs to be reversed.
Can you address the timeliness of the filing here and its impact
Sure. So
going forward with respect to the primary and with respect to the potential candidacy?
Sure. So the relief that the plaintiffs are seeking here, which is to clear a path for Mr. Montserrat to run in this election, it's barred by laches because they filed their lawsuit March 31st. This is when the election is right around the corner. And this is a local law that's been in effect for over 2 years, since February 2021. If they're supporters of Mr. Montserrat, they knew that this law would have barred his candidacy, and there was no reason for them to wait.
They actually commenced a lawsuit a while back too, right?
There were other supporters of Mr. Montserrat that commenced a lawsuit. And
This isn't the first one.
no, there have been many lawsuits that have challenged this local
But
law.
when did he declare his candidacy?
We know that he was circulating designating petitions by the end of February. Plaintiffs say that they signed them in mid-March, but because this is not an election law case, you don't need to have the formality of a designated petition.
But the argument could be made that they were not aware that he was going to run until.
And they have argued that, Your Honor, but Mr. Montserrat, he has run for the seat in every one of the last 3 elections. And he's run for 4 other campaigns since he's been released from prison. So his candidacy was entirely predictable. And if they had any doubt, they could have simply asked him. They're bringing up.
If they had filed this lawsuit before he started petitioning, wouldn't you have argued they didn't have standing?
To bring a plenary action challenging a local law, as long as it's I don't think we would necessarily argue that they had no standing to do that because they want to vote for someone who would be barred by the local law if he chose to run. And they didn't even try to challenge it sooner. There were, again, a raft of other lawsuits challenging Local Law 15 in 2021, and then nothing for 2 years until March 31st, right before this election.
So does expedited review of this lawsuit, expedited review of the applications here, does that make a difference? Does that ameliorate the impact on the primary itself?
We think the sooner this is resolved, the better, of course, Your Honor, but there's still a lot of uncertainty about whether there even is a primary in this district because Mr. Montserrat is the only challenger to the incumbent. So whether he can run or not determines whether there even is a primary. So the uncertainty created by this ruling.
Well, the Supreme Court's rulings actually state that he would be on the ballot.
It did not, Your Honor. And again, there's a lot of uncertainty about what's going to happen in the election.
Well, that was the other thing. I was really not clear exactly what the decision, what the bottom line of the decision is. It was declared unconstitutional, but I didn't see that. Therefore, he would be able to. His name would be placed on the ballot.
And the Board of Election is not a party to this case.
Right. That was
Yes.
another question I had.
Yes.
Right.
So
What happens now? How do we work around that? Because the Board of Elections is not now being told that they have to place his name on the ballot. That's not what this decision says. So I'm not seeing where it gets us. or at least where it gets to plaintiffs.
Again, I think it just creates a lot of confusion about what's happening in this election and whether there is even an election in this district.
Thank you. You have time on rebuttal.
Good afternoon. May it please the court. My name is Jerry Goldfeder, and I represent the respondents here.
So, counsel, as a practical matter, the Board of Elections is not a party to this lawsuit,
Right.
or was not a party to this action.
So there was a companion action, an Article 16 under the election law action brought by Montserrat. That was before Justice Billings. We moved to intervene. City opposed it. It was denied. Justice Billings said that since he was thrown off the ballot by the Board of Elections because of Local Law 5, that Justice Billings would defer to Justice Sweeting, who had this case, and that he would continue to be off the ballot unless and until Justice Sweeting ruled the law invalid. Justice Sweeting ruled the law invalid, and therefore Justice Billings was ready to then reverse herself, as she said she would, but the city moved for a stay, and this court granted a stay. So therefore, Justice Billings could not direct the Board of Elections to put him on the ballot. So if this court affirms or reaches another decision that invalidates the law, Justice Billings will, in fact, direct the board to put him on the ballot. And as counsel has said, that if he is not on the ballot, there won't be a primary. Because as I'm sure that you know, if there's only one candidate, there's no primary whatsoever. So this has a real impact
Well, let me just
on
ask
the
you
voters.
this question, and just in terms of how you just explained all the steps in terms of Billings and Sweeting.
Yes.
How do we view that particular argument in light of this court's decision in Herkman versus Hochul that we decided last year in terms of timing?
We brought this case, we had to bring this case as a plenary action because voters are not permitted to be parties in an Article 16 election law case, only candidates and objectors. We brought this case.
Plenary action, you didn't have to wait until March to.
Well, yes, we did. And the reason we had to, despite what counsel has said, is because this is a constitutional argument, and voters can only bring a case when they're injured. The question that was raised about whether it would be premature to have brought this case 6 months ago or 2 years ago, these voters would not have been injured.
Why not?
And therefore,
Why not? I'm not understanding why would they not be. Why would they not have been injured?
because voters cannot say, voters can only say that their rights to free associate with with each other and their preferred candidate only when there's an election and only when they are deprived of being able to vote for that candidate. That's what Anderson against Celebrezzi is all about, Supreme Court of the United States and its progeny, constitutional jurisprudence in this space.
So you had to wait until he declared his candidacy.
We had to wait until there was a petition, until he was actually a candidate.
So, counsel, what's the earliest date, in your view, that this action could have been filed?
I'm sorry, but I didn't
What's
hear you.
the earliest date, in your view, that this action could have been filed?
In March, as a matter of fact. Petitioning started February 28th. For counsel to say they could have simply asked Mr. Montserrat if he was going to run, or because he's a perennial candidate and he always runs, is really not an answer. It's sidestepping the issue. They can only bring the case.
The other cases that challenged this law, apparently on his behalf, were not dismissed for lack of standing. In fact, the plaintiffs in one of the cases just abandoned the case.
Well, that's because they failed to give the city notice because a constitutional issue was being alleged. So there were only procedural issues and jurisprudential issues, jurisdictional issues, and the merits were never reached.
But there were other instances where preliminary injunctions were sought and then the cases were abandoned.
I'm sorry, but I can't hear you.
There were other instances where the preliminary injunction was sought and then because it was denied, the plaintiff dropped their case in the Southern District, I believe.
They did. But these voters are separate and apart. The merits were never reached in this case. These voters can't be deprived of their day in court because other parties failed in their attempt to challenge the law in a proper way procedurally. These voters have a constitutional deprivation only when there is a candidate, only when there's an election. So they had to bring it at this point. There's no laches issues, there's no standing issue, and Corporation Counsel said that in colloquy before the Supreme Court, said, oh, that's only an issue if there's a preliminary injunction. And by the way, for the Corporation Counsel to say, well, I made a typo, is a little astounding, because when they said that there was a cross motion, there may not have been a formal cross motion, but in papers where we submitted to the court in April, when we tried to move up the calendar, which the city repeatedly opposed, we said we were going to move pursuant to 3211C to convert this into a summary judgment motion. They were on notice.
Counsel, what's your response to the Supreme Court made their decision on retroactivity?
Yes.
There's no retroactivity here. What's the retroactive effect?
The court made a determination. First of all, the court came up with this on its own. We didn't argue this. They didn't argue this. That is clear, and we.
But the basis of the decision is based on retroactivity. So if you're saying that these arguments are not raised, the decision itself is infirm, right? I mean, it's basing on an argument that nobody raised.
Nobody raised it, but I think it's a valid decision on this ground, which is there is no legislative history that was asked. None whatsoever, no analysis, no statements, no memoranda. There is none. There's no legislative history that deals with this issue, and given that fact, the court looks at the texts and understands that the law that governs these kinds of cases really frowns upon retroactivity.
Where does the court say this?
In the transcript. In the hearing transcript, which she then said it's incorporated by reference within the decision.
I didn't see it. Go ahead.
Counsel, there are at least 2 Court of Appeals cases, Miller versus De Buono and Leon St. Clair Nation versus City of New York, that make it clear that imposing going forward qualifications tied to past conduct is not a retroactive statute.
Right, and those cases were not cited by Supreme Court. There were no cases that I saw that were cited by Supreme Court, and I didn't even see the analysis that you just made reference to in terms of the legislative history. But even that analysis, standing by itself, would not be sufficient to form the basis for such a decision, stating that Local Law 15 is unconstitutional.
Your Honors, I'm in the unfortunate position to have to ask you to affirm a decision that is.
She didn't address any of the, but none of the issues that you're raising there are substantive. At least I didn't see it in the transcript or in the decision. I mean, the substantive issues are clear to me. There's, in
substantive issues, we raised that. That's all we argued.
But
she didn't address them.
She didn't address them. She didn't tell us how we're going.
But you can. You have the authority to do so. Just as that court, just as Supreme Court, had the authority to convert this to a summary judgment motion. After all,
well, that's another issue, because how do you then convert it without notice to the people that you're converting it, and without giving them an opportunity to respond and to brief the issues?
They briefed the issues. All the issues that we raised were 3: the constitutional issues, the First Amendment issue, which we raised, which they briefed, which we argued. The preemption issue, which we raised, which we briefed, which they argued, and they briefed, and the referendum issue.
None of which she decided on, right?
Well,
I think that's a problem. That's a problem. I think that's great. That they briefed all those issues, but she didn't decide on any of those issues.
And that's why I put in my brief in this court that you have the authority, and there are cases that say that you have the authority.
We have the authority.
Why would we do that? We normally, if the trial court hasn't decided something, we don't usually decide it. We send it back for them to decide it.
Not necessarily. Not necessarily. The Court of Appeals.
That's what we do.
So what's the good of having a trial court or a motion court if we're going to decide all the motions? I mean,
Come up here on the first instance.
Yeah, exactly.
Well, let me ask you another question. If we were to
This
just.
is the basic issue here.
Okay,
Yes? No, but please, Justice.
I got a simple question.
No,
Go ahead.
please.
No, answer the question before you forget it.
The answer is, the Court of Appeals in the state of New York has said and has acted that you have the authority to look at the record, to look at the issues that were argued, and render a decision. You have that choice because we've argued that. We argued it below and we've argued it here. The issue of the constitutionality, there's no city interest that's been stated. There's no compelling interest, there's no rational basis. There's nothing in the record by the city in Supreme Court at all as to what the city's interest. Look, Anderson against Celebrezzi, you raise the constitutional issue. Obviously, they're infringed upon. They're deprived of being able to associate with each other and to vote for their preferred candidate. That is permitted only when there's a compelling interest. The city is silent on what their interest
I'm
is.
sorry, I didn't, that was one thing that I thought was very clear in the papers, is their statement of what the interest is in this statute.
In this case, yes, they put it in their appellate brief, and it was never argued or in a brief before Supreme Court. If you're willing
That's
to...
because the merits weren't before Supreme Court either.
Yes, they were. We argued the constitutional issues. We argued preemption. That's what the memorandum of law dealt with, those very issues. And that's what's before this court. So now they're saying, well, there is a compelling interest by the city to protect the public fisc. Well, that's why we have the criminal statutes. That's how you protect the public.
Well, that's your argument. That's your argument, and their argument is something totally different. So do we?
Right, and
So
it's
you're
up
saying
to-
that we should make a determination that, okay, the criminal laws are sufficient in order to protect the public fisc?
When it comes to protecting constitutional rights, the answer is yes, that is sufficient, because there is no interest in depriving the voters of their opportunity.
Is there not an interest in ensuring that individuals who run for public office and who are in public office have not committed crimes against the public?
We
by
don't do this
taking
in the
monies?
United States of America. We don't prevent voters from voting for Nazis, for KKK members, for socialists, for communists. We don't do
Counsel.
that.
Okay, that's apples and
That's-
oranges. My question was in terms
They're
of
both fruit.
the statute. I'm with
They're
you.
both fruit, yeah, okay.
Yeah, I know, but strange fruit. But my question is in terms of the history and the basis for the statute. That's the issue. You just said that the people had not come forth, the Corporation Council of the city had not come forth with a viable argument or a rational argument. And I'm just saying that that's their argument, and why is that
So
not
if
plausible?
that's their argument, you have to weigh whether or not that's sufficient of a sufficiency, whether it's sufficient to deprive voters of their First Amendment rights.
Right, and we looked at those cases that were mentioned that we have decided, including last year the case against Governor Hochul, same thing, and and then we would make our determination. Justice Gonzalez, you had a question, and Justice Owen, you had a question.
I'm just looking at Public Officers Law, Section 3, which says that no person shall be capable of holding a civil office who shall stand convicted of a felony, and then it enumerates certain instances. You're weighing voters' free choice to elect a person who they believe is capable against, as my colleagues have been discussing with you and querying here. There are people who should not run for office. Would you agree?
No, actually, I would not.
In your
agree.
view, all people there should be no qualification laws?
No. There
No,
should be
but that's what I'm asking you.
I'm sorry.
Is there any
There
validity?
are residency qualifications, there are age qualifications.
Yes.
The state of New York, and this is the preemption issue, it conflates with the constitutional issue, but it's a preemption issue. The state of New York is,
And what you're saying is that as to criminal matters, a person's past criminal record should not weigh as a factor in saying that this person's not qualified.
that's why I submitted the affidavit of Assemblyman Edward Gibbs, who went to prison for manslaughter, and the affidavit.
But
and he's an
manslaughter,
assemblyman.
if I may, manslaughter is not what's at issue here. It's the protection of the public fisc, is it not?
If the state of New York wanted to enact laws relating to what you call the public fisc, or what counsel calls the public fisc, public corruption crimes, admitted public corruption crimes, if they wanted to do that, they've had the opportunity to do that, and they've refrained from doing it. There have been any number of bills in the hopper, it's in my brief, that coincide with these statutory provisions in this particular law. They've refused to pass it. Look, the city had the opportunity, if it really had this interest that it wanted.
Aren't you arguing against yourself right now?
I'm sorry?
Aren't you arguing against yourself?
No, not at all. The city of New York could have asked Albany to pass that legislation.
Is it your position that the city of New York cannot pass their own regulations and laws? I'm not.
With regard to this, because the state has occupied the field.
Has it, counsel, when it comes to the city council?
Yes. With regard to this, that's what public officers
Are
law.
you saying that New York City has no right to pass laws concerning eligibility for the city council?
It had no right to pass this law because this area has been occupied by the public officers law. And this law is inconsistent with the public officers law. And this is a specific law, and the city cannot pass, nor any locality can pass a specific law that's inconsistent with the general law of the public officers law 3. Now, if you look at public officers law,
And we will do so. Thank you. Your time is run. I'm sorry, Judge Owen, did you have a? No, thank you very much.
Thank you, Your Honor.
Counsel, would you address, please, the issue that was just being discussed, that in your adversary's view, New York City has no authority whatsoever to pass a law concerning the city council and the eligibility of a candidate to run for office if that person has a criminal record
It's incorrect.
with respect to certain offenses?
It's incorrect, Your Honor, because there's no conflict preemption, because there's no direct conflict between public officers law
You're
and.
not getting rid of the public officers law, you're building on top of it.
Exactly. It's consistent with the purposes and indeed with the means that the public officers law uses to fight corruption in this context. And there's no field preemption. There's no express statement of field preemption. There's none of the indicia of field preemption are present, as we've showed in our brief. And the municipal home rule law and the state constitution expressly reserve the power for localities to set qualifications.
So what's your response to council's invitation to us, basically saying that we should decide this issue, all these important pressing issues now on the constitutionality of local law 15, that we should grab the bull by the horns and just decide it? Because Supreme Court, in my mind, didn't address any of these major issues.
No, Your Honor, and this court could just reverse the Supreme Court's order based on the procedural problems we've talked about and because the merits are plainly and incorrectly wrong. There's no need to reach these other issues.
Let
But
me ask you this question. The candidate here, if we were to agree with you, when's the next opportunity to run for city council?
I believe it's every
2025?
I believe it's every 4 years, I
Yeah,
believe.
no, I think it's 2025 because this is sort of a decennial year. Yeah,
Council's telling me it's every 2
I kind of
years.
remember that.
Okay.
So it's 2025. So, it's like 2021, he commences his loop, doesn't do anything. 2023, we're here now. He's got another opportunity to run in 2025. So all this should be percolated and resolved by then in 2025 if we send it back down.
Well, the only problem is that your adversary claims that that's not possible until he actually starts petitioning. That the time doesn't start to run in terms of the ability to commence the action until he actually starts petitioning.
But that's, to bring a plenary action, you don't need to have the formalities of a designated
No,
petition.
but this suit would be the suit.
If we reverse, this case would still be alive, right? And you would then litigate the merits in the trial court.
Yes, Your Honor, but it wouldn't be in time for his candidacy, which is what the plaintiffs, have tried to rush this case for
But it would be in time
that
for
reason.
2025.
Depending upon the decision.
And I see I'm out of time, but I'd just like to raise one more point, Your Honors, is that the arguments that they're making on the First Amendment grounds, they're policy disagreements. If you look at Golden versus Clark, if you look at the Burdick case, it's very clear that that the government can set reasonable limits on candidate qualifications, and that's exactly what this is.
Thank you. Thank you both very much. People v. Rafael Davalos.
Good afternoon. Legal Aid Society by Catherine Pecor on behalf of the appellant Rafael Davalos. I'm happy to answer any questions about the legal standard, but I'll start with the merits. The record at this SOAR hearing established that the complainant sustained objectively minor scratches, bruises, and red marks on her skin. They required no treatment, didn't impair her functioning in any way, and caused only generalized pain and soreness.
Did the court in any way rely on the grand jury minutes? And if it did, is that sufficient?
So the grand jury minutes were essentially the totality of the record. That was the evidence that the SORA court relied on. The grand jury minutes themselves, in theory, grand jury minutes are sufficient to establish, they're deemed reliable and admissible.
Well, it's a little bit more than theory, right? I mean, we've held that they are sufficient, correct?
Yes, all I mean is that in this case, I think the grand jury testimony did not establish injuries that rose to the level of impairment of physical condition or substantial pain.
So you're saying that the strangling and the choking that allegedly caused her breathing to become impaired doesn't establish something that's more than slight or trivial pain, something more than petty slaps, shoves, and kicks?
So I think, Judge, that is accounted for by the 10 points under Factor 1. That goes to forcible compulsion. There's a wide body of case law that says essentially, regardless of the level of force used, there has to be some type of after effect that goes to substantial pain or impairment of physical condition. And we don't have that here. She said her testimony was basically, I had pain and I was sore.
Well, there was bruising, was there not?
There was.
I thought that there was subjective bruising.
Yes, so basically the injuries were some number of scratches or scrapes. The largest was 2 centimeters in length. There was a bruise of some unspecified size around her eye and red marks.
So you discount the rape itself as causing pain, am I right?
I think that if we rely on the rape itself, then what we're doing is essentially equating forcible compulsion with physical injury, and those are two distinct concepts on the risk assessment instrument. I think in all cases, the motive is to commit a forcible sexual assault. That's going to be true of all forcible sexual assaults, and I don't think that speaks at all to the physical injury that the complainant sustained. There's no evidence that that any of these scratches even bled. There's no evidence of how long they lasted. In fact, the physician's assistant testified that they would heal on their own in a couple of days. There's no photos. There's really not much to objectively assess the severity.
You don't need anything like the medical or the photographic documentation. Her testimony as to how it lasted for a couple of days would in fact be sufficient, right?
Whose testimony?
Law against to state the contrary.
So I'm sorry, you said her testimony that they lasted. Whose testimony are you referring to?
You just said, and we're talking about her subjective complaints here based upon the forcible compulsion for the rape, which resulted in injuries that she testified to in her grand jury testimony, which was the basis for the SORA court assessing those 15 points. We don't need really anything more than that. We don't need medical documentation or photographic evidence. We can, in fact, turn to those grand jury minutes or her testimony, right?
Yes, certainly subjective testimony can be sufficient, but it has to be more than just some pain. She says, I had pain and I was sore. Substantial pain is something more than just pain.
Well, during the rape itself, he strangled her. He was choking and strangling her. So that accounted for the bruising and the pain to the neck. And also, you mentioned the physician's assistant, who I guess you saw at the hospital after the rape kit was done. That individual stated that their opinion was that the bruising or whatever would heal within a few days. So again, we now have some testimony evidence that it's lasting for a specific period of time.
I don't think that establishes that they lasted a few days. There's no testimony to that effect. What she's saying is essentially that these injuries are self-healing and don't need treatment.
Well, I think what he or she said, that they would heal in a couple of days.
That's right. I mean, I don't think that's clear and convincing. I think that's just, kind of the statement that these are not injuries that require medical intervention.
So we're back to the totality of the evidence, the testimony in the grand jury of the complainant, also the statements by the physician's assistant. So I'm not understanding why that is not sufficient.
If the complainant had suffered substantial pain or something more than just pain, or her physical condition was compromised in some way after the assault, I think she would have testified to that effect. And the physician's assistant would have indicated if something needed treatment, if something was worrisome. But when she came to the hospital, she wasn't even complaining of pain or injuries. She came to get a forensic examination done. That was the primary purpose of it.
Well,
So, I think
I don't know if she had just been raped. She had been strangled and she'd been choked. I don't know that what her complaints would be other than the actual rape. But I think that the question, again, as stated by my colleague, is whether or not the grand jury minutes are sufficient in terms of the points, the 15 points.
I think they're ambiguous, and I think there's too many unanswered questions here for it to be clear and convincing.
Thank you.
May it please the court, Sharon Knight for the people. Your Honor, the Sora court properly found that the people proved by clear and convincing evidence that the defendant caused this young 17-year-old victim physical injury. If you look at the
Could you address the statement counsel just made about that the record was ambiguous about the extent of her injuries?
The record was not at all ambiguous. We had the testimony of the victim. She testified that she had bruises, large bruises on her neck, bruises on her eyes, abrasions, not little scrapes. These are also abrasions, and as we'll get to that. So abrasions. She also testified in detail about the actual assault, which was brutal. Grabbed her off the street from behind, threw her into an alley, basically threw her all around this alley, forcing her to perform sexual acts on him and for him to perform them on her. Strangled her with his hands, and we know that because the testifying physician said that she still had the red marks. That's how hard he actually pressed into her throat. And we also know that he had her from behind in a chokehold, and she said she tried to scream, but the breath just got out of her. She was very clear in her testimony. This was a brutal rape, and when you look at these four factors, you're looking at the nature of the injuries, a subjective view. So we have that, which is the testimony of this victim. You're getting an objective view, which is the testimony, the grand jury testimony of this physician, who went into great detail about numerous abrasions. And he did say he would take a couple of days to heal. And yes, that does mean they will last a couple of days. And also just to address a point that she made, People v. Parrish, the pain does not need to be severe or intense. It's just more than slight or trivial pain. This was definitely more than petty slaps, shoves, kicks, and the like. I mean, this is strangulation, choking, but also just to move on with those four factors, the other factor is whether or not she sought medical treatment. The second she escaped from this defendant, she ran upstairs and she called.
Well, I think your adversary may have been arguing that she sought medical treatment for the rape, or was a forensic examination, as opposed to medical treatment for the bruising, et cetera.
There's no evidence in the record. She didn't testify that I was raped and I wanted to get a rape kit, so I called them immediately. No, she called 911. There's just no evidence to back that statement at all. So we know she sought medical treatment. And then this is the most important factor, and this is what distinguishes this case here from the many cases that defendants cited, and that's the defendant's motive. This is a rape, okay? He is attacking her and inflicting pain on her to overcome her will. This is not a case where it's just to maybe harm the person, or that's the difference. This is a rape case, and this court very recently, this year, in People v. Garcia Ponce, very similar circumstances, said that 15 points were properly assessed. And described the grand jury testimony in that case, described defendant's violent attacks, inflicted bruises, scratches, scrapes, lacerations, bleeding, resulting pain, and that supports an inference of substantial pain. And there's also People v. Sierra. So, and the victim does not have to say, I suffered substantial pain. People v. Rojas says that specifically. So, Your Honor, there definitely was clear and convincing evidence here that this defendant did cause physical injury and was properly assessed 15 points under Factor 1. If there are no questions, I ask that you affirm the order.
Thank you.
So regarding the complainant's motive in going to the hospital, there is evidence in the record to that effect. The physician's assistant said that she came and she came specifically to have a forensic sexual assault examination. She didn't say she came because she was in pain and she needed, antibiotics or something like that. As far as motive goes,
Well, does it really matter if the main concern that was articulated was the fact that she had been raped and not that she was that she had experienced bruising and other injuries?
I think that is crucial, and that's why I think that goes to the force that was used to commit the sexual assault. The motive to overcome someone's will that's always going to be the motive in a forcible rape case. That's going to be true.
But it seems to me that a victim of rape is not going to parse that she wants to go to the hospital because she was raped and she wants whatever medical care she needs as a result of that.
Sure.
Yeah, why would
She's
she
not
parse
going to
it?
say, gee, I want you to pay attention to the bruises I got while I was being raped. She's going to say I was raped.
Yeah, I don't think you're going to parse it out. I mean, maybe that was, I wouldn't even say one was, the rape itself was her main concern and the bruising or whatever was a secondary concern. I think it all goes together, and I'm not really clear why you're parsing it out.
I don't think it actually does matter that much because at the end of the day, if it is ambiguous, that's not clear and convincing evidence.
Well, it does matter because if we were to agree with you, we would be setting an interesting precedent going forward that when you have rape situations that you need to parcel it out between what is rape and what is actually a physical injury. And I'm not so sure I'm kind of going to want to go down that road saying that, at any time when we're dealing with sorry situations like this, that to prove clear and convincing evidence, you need to demonstrate, the people need to demonstrate on top of not only the rape, but also that there was some substantial injury
Right.
to the victim.
I think it takes us back to the dark ages,
Yeah.
whether she fought or she didn't fight, which I don't think we need to get into.
But see, the risk assessment instrument does distinguish between those two concepts.
And that's for the court below to assess and look at the entire record to see whether or not there's clear and convincing evidence to assess the points that are assessed. Right?
And I think the court conflated those two concepts just as respondent is conflating them here. There's 10 points for forcible compulsion and there's 5 points for physical injury.
But I understand that, but the question is whether we can discern which of those is appropriate based on what complaint she made when she went to the emergency room. And if she went to the emergency room and said, I was raped, I want to be treated, that doesn't mean she wasn't physically bruised during the rape. And I don't think we can draw that inference, which you seem to be asking us to draw.
I don't think it's important to be able to draw that inference. I think the point is simply that there isn't a lot of information in the record about what her specific complaints were. I don't think it matters all that much because at the end of the day, what we have is a forcible rape. Yes, of course, he got 10 points for the forcible rape. There's not the
So what you're essentially asking us to do is decide that when you are raped, you are not in pain. When you are raped, you do not experience physical pain greater than a petty, what are the standard petty slap, shove, kick, and the like, more than slight or trivial pain. And I, for one, cannot go that far.
I'm not asking that, I'm not saying that rule applies across the board, but I don't think
If we were to agree with you, it would be the rule that would be going forward.
I don't think so because the court,
Okay.
you would still have to have something in the way of substantial pain or impairment of physical condition. And I just don't think that additional evidence is here.
Thank you. Thank you both. Hess v. EDR Assets.
Good afternoon, Your Honors, and may it please the court. Before turning to the place I'd been planning to start, I want to note that this morning the court
Counsel,
issued its
who do you
decision.
represent?
Oh, I'm sorry, for the defendants' appellants, EDR Assets and Parkoff Operating Corp. Before turning to the place I'd been planning to start, I want to note that this morning the court
I think
issued.
you're actually trying to looking for your name.
I'm sorry,
Your name.
Adrian
Say-
Koch.
Oh, I'm sorry.
Yes. Apologies.
It's okay.
The court issued its decision in Woodson versus Convent 1, on which counsel for the plaintiffs here told this court on page 7 of his brief would be decisive as to the issues raised on this appeal. We agree that it is, and we filed a copy on NICEF this morning. In Woodson, this court reversed an
Yeah,
award.
we have a copy of it, and I think 2 of my colleagues were on that bench, and so they may be a little bit familiar with the case.
Correct. And I don't plan on going into a lot of detail other than to say how it applies here, because in Woodson, this court reversed an award of summary judgment in favor of the plaintiff tenants on the question of whether the default formula applied, and it reiterated that application of the default formula requires a showing that a fraudulent scheme to remove an apartment from the protections of rent stabilization tainted the reliability of the rent on the base date. And it also reiterated that to support application of the default formula, the plaintiffs must submit evidence of a representation of material fact, falsity, scienter.
Counsel, I want to take us in a slightly different direction. I'm curious why your client didn't re-regulate apartments 4D, 7A, 7B, and 9A after receiving the January 2016 letter from DHCR telling them to do that.
Yes, Your Honor. So putting aside apartment 9A, because there was some confusion about that apartment, and the only relevant tenant of that apartment has actually opted out of the class. But putting that aside, the other 3 apartments, 4D, 7A, and 7B, in fact, were registered promptly in response to DHCR's notice of. It was not after the 2016 letter, but it was
when?
2017 January,
That's not
I believe.
promptly after January 2016, counsel.
Because, well,
That's a year plus later.
there was, because there
So
was.
going back to my question, why didn't they register those apartments promptly when they got the January 2016 letter from DHCR?
Those 4 apartments fell through the cracks. They realized, and it's in the record. It's in the so. First
And where
of
do
all,
we put that in our jurisprudence? How do we understand falling through the cracks?
It was a mistake.
It
was a mistake, Your Honor, and in fact, in the lower
And where does
court-
it say that in the papers?
In
Your papers. Where do you say that it was a mistake as to all 4 of those apartments? I don't want to.
It's
you can look for that.
it is in the record. It is in the opposing affidavit that when we got the notice that DHCR had commenced a proceeding, the defendants quickly realized that there were these apartments that actually had been deregulated during
Counsel,
J51.
why isn't that indicia of fraud?
Well, I'll say a couple of things. First, this is a motion first of all, this is a motion for summary judgment. This is not a motion to dismiss. All inferences are to be drawn in favor of the defendants. This is a motion for summary judgment on behalf of a class.
So why can't we infer fraud?
Because you need to draw all inferences in favor of the defendants on this motion for summary judgment. And these are not, even the lower court in Woodson declined to award summary judgment to the entire class based on conduct that was unique to 3 or 4 apartments.
Counsel, if
counsel-
20 apartments had fallen through the cracks, would that be enough to find fraud? As
Well,
opposed to just 4?
In Tribs, Your Honor, in Tribs, which plaintiff's counsel also said would be decisive as to this case, the tenant actually deregulated 30 apartments after Roberts and waited until 2020. They still weren't re-regulated then. And this court still found that summary judgment was improper because there hadn't been a finding, a sufficient showing of fraud. And the case law is very clear, not only Woodson, but also Casey and Regina and Sandlow and a number of the other cases cited in our brief, that that in order to support the default formula, the violation of the law has to be conscious and knowing and not the result of a
Right, but
mistake.
I think in this particular case, we have something that's a little bit different, right? You have a directive and an information going directly to the landlord saying, hey, listen, you did not do this. And then they still don't do that once they receive that directive.
Well, there are two
That's
classes.
not a misinterpretation, right? That's a blatant ignoring.
The directive that you're talking about, I believe, Your Honor, the 2016 letter, that was a form letter that was sent to 4,000 building owners. And this landlord, please.
Counsel, we're talking about this one, not the 4,000.
I understand, but this particular landlord had received a modest J51 benefit, $3,100 for the entire building over a course of 11 years. And the amount that it requested was specifically reduced by nearly 80%, precisely because most of the apartments in the building were not rent regulated. So when it got this letter in 2016 that talked about any apartment that was subject to rent stabilization at the date of the receipt of J51 benefits, it reasonably understood that that letter was not referring to these apartments, not the apartment occupied by the named plaintiff Hess, and not the apartment occupied by most of the class members. Yes, there were 3 apartments that are occupied by class members that had been deregulated during J51, and as to those, the landlord made a mistake. It realized its mistake before DHCR issued the order directing the apartments to be rent regulated, and it registered those apartments before that order. I would also, I see my time is up, I just want to mention one other thing, which
You
is
can
that
do so on rebuttal. Thank you.
Okay.
Good afternoon. Roger Sacker, Newman Ferrara. May it please the court.
So counsel, why wouldn't we look at, as the way that the situation unfolded here, as is it just being a misinterpretation and a mistake, that therefore Casey would apply? Why wouldn't we look at it that way?
Well, this is why Burroughs and Woodson in these cases are so troubling, because every landlord stands up and says, mistake. In Casey, remember, excuse me, and because there's a mistake, there's no scienter. In Casey, the landlord deregulated prior to Roberts, and Casey was filed literally on the eve of Gersten. What you have here is something very different. You have a landlord that ignored this court's determination.
Counsel, the way I look at it is that, you know, the landlord is, and all landlords that I've seen is arguing mistake or, you know, I didn't know, whatever. So if I were to agree with you, that would be now a bright line test saying mistake and whatever else you have as excuses are no longer valid and it's automatically fraud. I don't know if that's kind of harsh to say that, right?
That's what the legislature's about to do, Your Honor. And
Well, if they about to do it, have they done it yet?
they have not done it yet.
Okay, once they do it, I'll change my mind.
All right, that's
All right?
you got a deal,
Right?
Your Honor.
But at this point, you're asking, fraud is to me a concept that's very, you know, amorphous. And it's all talks about what the person's thinking and what their intent is. But when there's, I mean, I'm not to say that they can prove mistake. I mean, that's going to be for a trial of fact to say whether or not they believe them or not. And at that point, if they don't believe them, then you got a lock solid case at that point, right?
But this is the issue. Prior to Regina and prior to footnote 7, the 3 seminal cases, Thornton, Grimm, and Connaughton, did not adopt a common law fraud standard. In fact, in Thornton, you could never have reliance because the landlord and the tenants conspired together. Grimm, they actually represented to the tenants, I'm doing something illegal. The tenants said, okay. Connaughton, they say tenants aren't alleging a generalized claim of
Yeah,
fraud.
but in this case, let's look at this case, though. Let's look at this case. This case that they, according to what was represented, a year after they got the DHCR notice, they re-regulated the apartments.
It was actually 18 months.
I'm sorry?
18 months,
18 months, they did it, okay? And then they're saying, look, it fell through the cracks. I mean, you know, okay, that's what they're saying. Who knows if that's a valid, if that's a credible argument, but that's something that's a factual issue to me. Because you're relying on all the other cases were kind of like a little bit, the facts were a little bit more severe. But, you know, I'm not so sure that, you know, fraud can be just automatically decided based on what you have in front of you without going into further detail, or at least thinking, what's the person thinking, right?
Well, then how do we get to Montera's, you can't claim willful ignorance of the law? Because this,
Counsel, here we have a different problem, which is HPD sent them a letter which basically said, it's okay, don't regulate those apartments. And so it seems to me they were stuck between HPD saying, you don't have to regulate those apartments, and then a few years later, DHCR said, yeah, you really do. I'm troubled by how they were supposed to understand that.
there's two intervening things happened, Your Honor. That HPD letter came out pre-Roberts, pre-Gersten. Then Roberts comes out, it says you can't deregulate units in a J51. Then this
Right,
court
but
issues
they
a...
thought they didn't have to, they weren't deregulating because they weren't regulated at all, so they didn't think it applied to them.
Except
Or at least they
Gersten then
claimed.
comes out and says you have to re-regulate all the units. So the only way you can buy this is if they're allowed to ignore Gersten. And I am really troubled if we're saying
Why
that you can
shouldn't
ignore
there be
this
a
court.
trial about this to determine the scienter issue?
Because Sienter, if they knew the law and they violated it, we got Sienter.
Well, that's the whole point. Did they know the law?
If they didn't, and this is Montero, willful ignorance, what steps did they take after Gersten came out to know their legal requirements? The record demonstrates.
You try a fact to figure
Well,
that
that's the
one
whole
out.
point, whether the ignorance
Willful ignorance.
was willful or not.
Well,
Because
I mean,
now on
that's-
these facts, you're going to say on these facts, it's always willful ignorance. And
If-
I'm not so sure I want
if
to say
footnote 7 in Regina governs, if footnote 7 in Regina doesn't govern, then we don't have to demonstrate these common law facts, which is why we're asking that boroughs go up. Legal Aid joined us today with a request for an amicus briefing that it go up. And let's let the Court of Appeals figure this one out, because I think it's ripe.
Okay, thank you.
They're going to be very busy.
I know.
They're going to be very busy.
What'd you ask for?
Just quickly to address a few of the things that came up on Mr. Sacker's argument, and also to give you the record citation that I was mentioning before. Page 1076, paragraph 30, note 5 of the record is where we spoke in the opposing affidavit of what happened with respect to those 3 apartments that were deregulated during J51 that the landlord didn't realize until later. In addition, the argument that the treatment of those 3 apartments is somehow an indicia of fraud was not made below. This is
Yeah,
I disagree. I thought it was very clear in the papers below.
in the
That's how
lower
I came up with that list of apartments.
In the lower court, the plaintiff said that in response to DHCR's notice, we re-regulated 3 apartments, and that was those 3. Now, they are saying that the fact that we didn't re-regulate those 3 apartments sooner is somehow an indicia of fraud. So there has been a switch. But in all events, this is a class action case, and the case is represented by the plaintiff Hess and no one else, and her apartment was deregulated years before the J51 benefits commenced, and there's no claim that her rent was ever increased more than the RGB guidelines would have permitted. Regina is not the only Court of Appeals case that said that you needed indicia of fraud, of actual fraud. In Casey, the Court of Appeals said that conduct based on a misinterpretation of the law can't form a basis for application of the default formula, and Montera, on which Mr. Sacker likes to rely, was a summary judgment motion by the landlord, and this court held that summary judgment was not warranted because there were issues of fact as to whether the landlord acted based on a misunderstanding of the law or based on some kind of a willful ignorance of the law. That's exactly the same thing here. You cannot have summary judgment when there's an issue of fact as to whether the defendant simply made a mistake. I see my time is up.
Thank you. Marstella versus the City of New York.
May I proceed?
Please.
Jimmy Wagner, for the appellant petitioner. Good afternoon, Your Honors. Your Honors, the entirety of the reasoning that my client was denied his religious accommodation was a four-word phrase, does not meet criteria. Within the entire record, there is no explanation and no attempt to explain what the criteria was for an individual to obtain a religious accommodation. Some lower courts, Judge Bluth has called and described the does not meet criteria a hollow and generic phrase. Judge Hagler has called it.
Counsel, are you referring to the letter of denial dated February 8th, 2022?
No, that's not the final denial.
No, but this was the denial. The denial, this is the initial denial, right?
No, actually, if we look at the record.
It says the EEOD Division of the Police Department received your request for a reasonable accommodation to be exempt from the city's mandatory COVID-19 vaccination requirement. Upon careful review, the reasonable accommodation is denied due to the following reasons, and then it lists four. So that's the denial that we're talking about, right?
No, that's not the denial we're talking about. The denial we're talking about is the denial from the citywide appeal panel that occurs on June 30th.
So do we ignore the first denial, the February 8th denial that was appealed?
It's my understanding, Your Honor, when the petitioner, the appellant here, was required to exhaust all administrative remedies.
Correct.
Right. So in the course of exhausting all the administrative remedies, he goes to the citywide appeal panel. The citywide appeal panel is the final administrative remedy. And it's on that denial, does not meet criteria, that is before the lower court here.
But the
and
criteria
is now before this court.
If I may, the criteria is referenced in the February 8th denial, correct?
No, Your Honor, if the court was to take that position, that criteria from the February 8th denial, you'd be creating a record that's not within the record. There's nothing that states that the citywide appeal panel made its does not meet criteria on anything from that February 8th.
So what else would they be basing their determination on? It's an appeal from the February 8th, 2022 denial, right?
Yep.
So what else would they be basing their, I guess, affirmance of the denial on other than that denial?
Well, two things, Your Honor. For me to speculate what they were doing, we can't, and this court shouldn't either. But number two is the petitioner had a further appeal. After February 8th, he submits an appeal document where he addresses the concerns. So we look at this Christian petitioner. He says he does not want to take the vaccine for two primary reasons. Number one, it's association with the aborted fetal cells. And number two, it's the mark of the beast. Neither one of those.
Could you explain what the underlying religious doctrine is that was on which he was basing his argument for a religious exemption?
He's a Christian, Your Honor. For us here, for this court, the Supreme Court has stated time and time again, for courts to wade into these theological debates, it's not appropriate. We do know now that 100% those vaccines were tested and deviated from fetal abortion cells, which this Christian is against. And number two is he believes that this vaccine is associated with the mark of the beast. He references numerous items in biblical scripture. And it's not for us to question this man's...
Counsel, if I may, the petitioner primarily said that to act against his inner voice, his conscience, would be an act against God. And he later says, though our consciences may be misinformed, it still speaks with a divine authority that we may disobey, but we may find difficult to ignore. So to the extent that a conscience is, by definition, personal and subjective, how does that comport with the the exemption requirement that a sincerely held religious, moral, or ethical belief may be a basis for a religious accommodation, but not a request based solely on a personal, political, or philosophical preference?
Well, number one is I cannot believe that anybody could potentially read Mr. Marstella's religious accommodation application and think it is anything but a religious accommodation application.
Why? Because he talks about the Holy Spirit.
That's correct, Your Honor.
But again, the denial, and I want to focus on the February 8th denial. It states it was denied because objection was personal, political, or philosophical. Statement does not appear to be written by the applicant. Generic statement that does not support candidate's request. Written statement does not set forth how religious tenets conflict with vaccine requirement. No demonstrated history of vaccination/medicine refusal. So where in his application does he specifically state how these held religious tenets conflict with vaccine requirement?
It's very simple. First, let's go back to the abortion. He states that it's just the same as the concept of the fruit of the poisonous tree. If my client was sitting before you guys as a criminal and the government had fruit of the poisonous tree in some type of evidentiary setting, you would not use that fruit of the poisonous tree evidence against him. Here, my client is a police officer. What he's saying is these vaccines, in some method, were derived from aborted fetuses. He does not want to be associated with those aborted fetuses.
Does being a police officer conflict with Christian values as well? That, do not kill thing?
I don't think there's any.
I mean, I'm just wondering. But again, I don't understand. His application just kind of throws out these words in terms of, I would be abandoning my faith and my God. How? He doesn't explain how.
Your Honor, and I think in all fairness to the applicant here, let's take a look at the circumstances. First of all, New York City human rights law is very, very clear. We're not talking New York State. We're not talking Title VII. New York City human rights law says that everybody shall be granted an accommodation if the accommodation is not an undue burden. We know the accommodation of weekly testing was not an undue burden because the city had granted it. In fact, the city's own papers state they granted it to 176 people.
Yeah, who were able to make out the requirements, and they stated that he was unable to do so, and they included information on how he could appeal.
But what? Oh, and you're right. You're talking about a February 8th letter. So
Yes.
let's move forward to the final determination. Does not meet criteria.
Counsel, they're related.
No.
The appeal concerns the February 8th letter. You can't just bypass it. It exists.
Judge Gonzalez.
It refers to the criteria, when the later letter refers to criteria, it refers back to the February 8th letter.
And in fact, it also mentions the issue about the lack of proof on prior vaccinations that wasn't there. So it says more than just a simple page that says does not meet criteria.
No, that's not what the record reflects here. The record here completely, 100% does, 4 ominous words, does not meet criteria, is exactly what the record here reflects.
So your argument is that on the appeal, that the citywide panel's determination was based on what? Nothing?
No, it was a rubber stamp of the original denial, but we don't know. For the court, for my client to get his due process that he's entitled to under the law, this court has stated numerous times there has to be a recitation of the facts.
But
there's nothing here. It's 4 words.
Wait. But the original decision, the February decision, set out.
It's not even the original decision, Judge.
Excuse me, counsel. The original decision set out a set of criteria. The decision that affirmed it said does not meet criteria. That's like if we got a well-reasoned decision from the trial court and we say affirmed on the grounds below. We're allowed to do that, and that's essentially what this did. Why is that improper?
Because you're speculating as to
I'm not speculating. I'm looking
There's
at the
nothing in the
document.
record to show, because after February 8th, my client submits further documentation. He submits a further appeal. He addresses those very issues. The February 8th letter isn't criteria, it's conclusions. It's a bunch of conclusions.
No, it's their determination, it's their findings. It states it's denied due to the following reasons.
We have other issues within the petition that weren't addressed. As we just stated, the record reflects that 176 people were granted a religious accommodation. The Constitution of the state of New York does not permit does not allow some religious accommodations to be given greater preference over other religious accommodations.
But that's
We-
not what happened here.
It is exactly what
it's
happened.
An issue of proof, right? You still have to, you're required to be able to prove that the religious accommodation applies to you if you're requesting it. That's what the issue is, not that it was just denied blanket. There were issues that were raised that he did not submit the sufficient proof.
Well,
That was the basis.
And part of the problem, the reason why this determination does not meet criteria, was arbitrary and capricious, was because number one is the city didn't file its own guidelines. It made up its own rules. Under the city guidelines, under their own DCAS guidelines, they were supposed to grant, it says, shall accommodate the religious accommodation unless it's an undue hardship.
So let me remind you, counsel, that the form that was used came about as a result of an earlier decision, 2021, December 2021, within the time frame of the pandemic, right? PBA, what is it? PBA on behalf of its members, that's all that it says here, versus
It's against
de
de Blasio. We'll talk about that on rebuttal. Thank you.
Good afternoon, and may it please the court. Chloe Moon on behalf of respondents. I'd like to begin by putting the case into context. NYPD received over 7,000 requests for religious accommodation from the vaccine. Nonetheless, NYPD reviewed each request individually on its own facts, its own merits, and here, based on Marsteller's specific submissions, it's clear that NYPD's denial was rational.
In the June 30th appeals denial, can you explain to us what is meant by does not meet criteria?
Absolutely. So first, you have the Eichenholz affirmation in the record at 282 that explains exactly what is meant by that. But it's also clear from the citywide panel's determination, it says explicitly at R82 that the citywide panel had carefully reviewed the agency's determination, all of the documentation submitted to the agency, and the additional information submitted in connection with the appeal. The citywide panel, as this court's colloquy has already shown, made it very clear that it was incorporating the February 8th denial into its reasoning. And that's all that's required here, is that there's rational
How is it
basis in the
clear
record.
to the petitioner that it incorporated the February 8th, 2022 findings?
Yeah, so I think that language that I just quoted sends that signal, but also it's my understanding that not all of the citywide panel had this exact language. So here we have it. Here we know that the citywide panel is explicitly incorporating and returning to that February 8th denial that's in the record as its reasoning. And that's what it reviewed to get here. And this is merely applying settled principles of Article 78 review. It's rational basis in the record. Both the February 8th denial and the citywide panel had that rational basis in the record. What Marsteller is actually asking here is for the court to substitute its own judgment for that of the agency. And here that's simply not allowed.
So not necessarily that the issue is moot at this time, but the decision was that the order was dated January 9, 2023, right? Mayor Adams rescinded the policy February of 2023. So what's the status now?
Yes, Your Honor. So it is my understanding that petitioner was not placed on leave without pay. And so it is unclear if Marsteller has lost even a single penny here. Of course, we haven't argued that in our brief, so we are standing on the merits here, but there is a question of whether this entire matter is moot.
So, counsel, your adversary says that he's emphasized the language that talks about being a Christian, not that this vaccine has the mark of the beast, and that it concerns abortion, to which he is opposed because the stem cells are used to create the vaccine. What say you in response as to the allegation that this is an absolute violation of religious freedom?
Yes, Your Honor. So I think as we try to lay out in our brief, what's really happening here is that as the Eichenholz affirmation has made clear, this is a selective refusal for a specific vaccine. Even his reply brief at 15 says that he's arguing that the city is rejecting the possibility of religiously significant distinctions between the COVID vaccine and other medications. ultimately, that's his burden to have shown in that request. There's really no connection. There's no connective tissue between his personal aversion to the vaccine and this personal conscience issue and a larger religious comprehensive belief system. And that's what's borne out by this record. And that's why the NYPD decision is rational here, is that you don't have that
The
connective
bottom line
tissue.
is that you have an Article 78 proceeding that challenges either it's arbitrary, capricious, or irrational, right? Those are the two standards here. I would gather in the record here that there are indications where other other applications for religious exemptions have been denied also, right? So the bottom line is what this is asking us on this appeal is us supposed to disagree with what the administrative agency has done in terms of deciding whether or not there is a religious exemption, right? I mean, in the past, you said over 7,000 applications came in. I doubt there was 6,999 that were granted and one was denied, right?
Correct, Your Honor. Yes. And ultimately, that's what we think is at bottom here, is that Marsteller is asking for the court to substitute its judgment. And that's simply, this is basic, settled Article 78 principles. The agency has reviewed this, has reviewed the record, and there's that rational basis in this record.
And there was a review, is that correct?
And there was a review, yes, Your Honor.
Thank you.
Thank you.
First things, the Judge Oing, you had just stated two of the reasons under Article 78. We also have another reason that an Article 78 can be granted, and that's in violation of the law, right? So we have New York City human rights law. New York City human rights law supersedes state human rights law and supersedes Title VII. New York City human rights law, in the record on page 141, I'm reading directly from New York City's policy for reasonable accommodations. This policy prohibits the denial of a religious accommodation that does not create an undue hardship for disabilities, religious beliefs, observances, and practices, victims of domestic violence, sexual stalking offenses, pregnancy, childbirth.
So, counsel, your basic argument is that so long as an applicant, I'm going to call it applicant, states, I object to taking the vaccine on religious grounds, cites biblical verses, as was the case here, and says, my conscience will not allow it, that's enough?
His God-given conscience. I don't say that. Beautiful City Council says that. The City Council has stated time and time again, New York City human rights law is to be given a wide liberal construction. Furthermore, when we're giving it that wide...
So the answer is yes, all someone has to do is state generically, I have religious beliefs, I'm going to quote from my religious text, this is what my conscience mandates me to do. Is that enough?
I think Mr. Marcellus says it's God-given conscience, but yes, that is enough under New York City human rights law, so long as there's no...
Where does it say that under New York City human rights law that all you have to do is state that you are, as he did, his religious beliefs and practices are grounded in Christianity and molded from his understanding of God's teachings as written in the Holy Bible, and states that he is sincere, has sincere and fundamental religious objection? Where in the Human Rights Act does it say that that's sufficient?
Sure. In Administrative Code 8-107...
That it would be sufficient to create a religious exemption for the COVID vaccine or for anything else?
So Administrative Code 8-107-28A1 states unequivocally, it shall be an unlawful discriminatory practice for an employer, labor organization or employment agency or an employee or agent thereof to refuse to otherwise fail to engage in a cooperative dialogue within a reasonable time with a person who has requested an accommodation for religious needs. We then move on to 8-107-28E, the determination that no reasonable accommodation would enable the person requesting an accommodation to satisfy the essential requisites of a job or enjoy the right or rights in question may only be made after the parties have engaged or the covered entity has attempted to engage in the cooperative dialogue. Now we move on to 8-107-3. It shall be an unlawful discriminatory practice for an employer, an employee, or agent thereof, and the because my time's running out, moving through to forego a practice such as a person's creed or religion, and the employer shall. The language given to us by New York City Council is shall. It's not maybe, could be, it's shall. And the employer shall make reasonable accommodation to the religious needs of such person.
And there has to be, and according to your argument, therefore, there does not have to be any correlation or any showing of the religious exemption or the request for the religious accommodation to the vaccine in this instance.
No, Judge, I think what what you're doing, Your Honor, is you're falling into the sand trap, right? It's what the petitioner believes, what the appellant believes. The appellant clearly believes that there's a religious connection to this vaccine. And that is what...
And there doesn't have to be any determination by the administrative body as to whether or not that is reasonable under the circumstances.
So long as there's not an undue burden on the employer. So long, if there was an undue burden on the employer, I would be talking to a different panel right now.
And the undue burden has not been shown where you have individuals who are not vaccinated, and then where you have a pandemic in terms of COVID?
In fact, our record explicitly states there was only one accommodation that would not be an undue burden, and that was the weekly testing. And that was the testing that Mr. Marstella had been doing for 2 years prior.
And so it's the petitioner or the employee who makes the determination as to whether it's unduly burdensome or not?
The burden is on the employer, to show that it's an undue hardship. It's not on the employee.
Thank you. Thank you both. People v. Anthony Jolly, Justice Pitt Burke is recused.
Good afternoon, Your Honor. May it please the court. I'm Stephen Amick from the Legal Aid Society here on behalf of Anthony Jolly. 5 years of probation were excessive in this case. This was Mr. Jolly's first and only arrest. He has no other criminal history.
Counsel, could you talk louder, please?
Oh, I apologize.
I think if you bring the mic up,
Yeah, I'll bring it
actually,
up. I'll stop stooping
Yeah,
over.
that's okay.
Yeah.
Thank
Sorry
you.
about that. This was Mr. Jolly's first and only arrest. He has no other criminal history.
So he was sentenced in 2020. When is the probation?
Yes.
Probation, right? When is his
January 6, 2020, and he got a 5-year term. So he's about 3.5 years through now.
He hasn't gotten any time off for the less is more?
And no, less is more. I don't think, no, that doesn't apply to probation yet, although that would be nice, right?
I thought there would be some time off. Also,
I think it's kind of a loophole there. It applies to parole and other forms of conditional release, but I think they left probation out for, hopefully they'll take care of that later, but he has not gotten any time off, and it's a 5-year term.
You got sentenced in January 6, 2020 to 5-year probation, right? So
Correct.
if you look at the math, it's January 6, 2025, right, that he'll be off probation.
Yes.
He's looking to reduce it by 3 years. He wants a 3-year probation, right?
Yes, we requested the minimum term. Obviously, anything that's even close to the amount of time he's served so far now would be fine.
how has he been negatively affected, his actions or what he wants to do, et cetera? How has he been negatively affected by the 5 years probation? And then how would he be negatively affected by 3 additional years probation?
So probation is a constraint on your liberty. There's plenty of things you're not permitted to do on probation. Our argument here is that, if, as happened here, the court and parties agree that a non-custodial sentence is warranted, 5 years of probation is excessive and counterproductive.
This is why my colleague asked the less is more statute. I mean, that now, I mean, it's not new anymore. This statute's been around now for over a year that, in terms of, it used to be a more drastic, draconian, probationary, if you just violate a single technicality, that's it. Now it's a more holistic approach. There's a lot of things, there are a lot of issues or a lot of accommodations that are being provide for, even travel within outside the area of where the person's supposed to be. So without that kind of understanding, you're asking us to reduce it by, 2 years.
Well, so the reality is that people on probation are at the highest risk of reoffense in the first year or two of probation. Longer terms don't reduce probationers. risks of reoffense, and essentially they create this risk of reincarceration without a corresponding public safety.
We don't know that. I mean, you don't have it. We don't know about the risk of reincarceration because we have this now new statute. And this statute, it's a different approach now.
To the extent the administration of probation has changed since the imposition of a sentence, I don't have all of that on the record
Yeah,
in
that's.
front of
I'm,
me.
I'm
in
only
terms
making
of,
this point because we get a lot of these arguments now, and we've all consistently, the benches consistently say, well, what does the less is more have to do? I mean, how's it impacting this? And we haven't gotten, at least in my mind, I haven't gotten a good answer yet.
Yeah, I mean, I am fairly certain that the less is more doesn't. You don't get to shave off the time the same way you did with parole as you do with probation. I'm pretty sure less is more doesn't apply.
It does shave off some time, but my question is, we get these cases, and normally there's something in terms of the probationer cannot travel, the probationer can't, get certain jobs, or he has to report. There was nothing in your brief as to, again, how these 5 years, how the sentence of 5 years probation has impeded his ability to do anything.
Yeah, I mean, I would love to add that that would all be beyond the record, the present burden of his probation term, whether or not he's getting along with a particular probation officer or not. What the burden is. It's highly discretionary. I couldn't use that.
Yeah, that's not a basis.
No, but our basis here is that the circumstances of this offense show that Mr. Jolly is not a threat to the community and doesn't require 5 years.
Well, that's another issue, because I also had a question as to the search warrant. I mean, there's a search warrant. The police, hopefully, don't just go in and search someone's apartment and then uncover a gun. So I was wondering the basis for the search warrant, what the probable cause was for the search warrant, also the fact that the gun and drugs were found in the apartment. And the people make the argument that although it was the defendant's first arrest, there was some issue as to his source of income. How was he able? I think this is the case where he made cash bail.
I would dispute all of that. The basis for the search warrant is completely outside of the record. The prosecution did, in its response, use the fact that he was able to pay his child support and the surcharge at the time of sentencing against him as a proof, despite unsteady employment, that he must have been making money unlawfully somehow. I found that to be wildly speculative.
Counsel, basically what you're saying is it's too much time, and that's that. I mean, the mitigation is that, he contributes money in child support. He previously he obtained a license to work as a security guard. I mean, there's no indication that he can no longer work as a security guard, for example. His exposure was how much? What was
His
maximum
exposure on this,
exposure?
the maximum, he pleaded guilty to functionally the top count because the top count dropped off. The prosecution conceded that. The exposure maximum was 1 1/3 to 4 years because it's a Class E felony.
He got probation instead, no jail time.
Correct. That's correct.
And that's what he bargained for, right?
He did bargain for that. And my position here now is that if you're going to say a non-custodial sentence is warranted, there's no sense in giving 5 years instead of 3.
Justice Gessner?
It's okay.
Thank you.
Good afternoon, Emily Aldridge for the People. Defendant's excessive sentence claim is foreclosed by his appeal waiver. His claim of misunderstanding of the right to appellate counsel is belied by counsel's presence here now. Defendant's negotiated sentence was fair and appropriate. Having probable cause to execute a search warrant, as Justice Weber noted, police found a loaded, operable firearm.
Talking about the waiver, I was trying to understand the argument. The argument was, I mean, the court, from my reading of the transcript, said all the buzzwords, but then he parcels out of that, saying that he wasn't told that he was waiving his right to appellate counsel. Something like that?
There's no indication in the waiver whatsoever. It simply talked about how.
But that's what his argument was, right?
Yeah,
I was trying to understand the argument.
My adversary's argument, respectfully, does not fully make sense to me either, if that is what your honor is indicating. But the negotiated sentence was fair and appropriate, having probable cause. I'm sorry, I said that already. In executing the search warrants, located a loaded, operable firearm, over 1/8 of an ounce of suspected cocaine. Despite facing up to 4 years in prison on the gun charge, he negotiated a sentence of 5 years probation. And then finally, relating to the Bruin claim, gun possession cannot be lawful if it is done without a license. If there are no questions, I rest in my brief. Thank you.
Thank you.
Could you address the waiver?
Yes, absolutely. The appeal waiver does not preclude modification of the sentence here. Waiver was invalid because the court's colloquy and the written waiver form both implied that Mr. Jolly had waived his right to counsel.
He waived his right to appellate
To appellate
counsel.
counsel,
He
yes.
wasn't told that by entering into the plea that he'd be waiving his right to appellate counsel.
Yes,
But,
so
I mean, that's like really drilling down, because if you're waiving your issues of appeal, other than, I think there are 4 issues that can't be waived, how does, you're asking now for us to say that we agree with you and say now we need the court below, the trial court still, in addition to say, on top of you waiving all these issues, except for these 4, and in addition, appellate counsel.
So there's an opportunity for the court, where the court goes back and says you can raise these issues, you can file a notice of appeal. It would be clearer if, unlike it was in this case, if the court explained at that point that you would have the right to raise those issues with the assistance of appellate counsel.
But we've already, I mean, the case law is clear. There's no specific colloquy that is
Yes,
necessary.
and there's tension in the case law between no particular litany is required and just the actual fact that the record has to reflect that the defendant fully appreciates the consequences.
And also, I was confused by your papers. Is there anything that says that he's waiving the right to appellate counsel?
No,
You don't
it's
waive
the
that, right?
court's description of the right to appeal includes a description of the right to counsel be appointed, this and that, and then the court says you are waiving your right to appeal. So it's bundled together.
Well, okay. I did not understand. I didn't understand that at all. How, by saying you're waiving your right to appeal, that would mean, first of all, that you're waiving all of your rights, because the court did talk about, did separate the rights correctly. And I certainly didn't see how that would be, that the court would be telling the defendant you're waiving your right to appellate counsel.
No, you're asking us to agree with you to say that you now want to put into that colloquy the waiver of appellate counsel.
That you're not waiving
That
your
you're
right
not
to
waiving
appellate
your-
counsel. That although you're waiving your right to appeal certain issues, you're not waiving your right to appellate counsel.
It's tricky because what's important is the defendant's appreciation of what are functionally complicated legal issues.
Yeah, I think it would be more complicated to a defendant if that were stated, because you're telling them you're waiving your right to appellate counsel for certain issues, but you're not waiving your right to appellate counsel as to other issues. I think it would be far too complicated. And then you would be here arguing on appeal. Thank you very much. Thank you both. Cresco Labs NY versus Fiorello Pharmaceuticals. I'm proud of you, Jeff. You have one for you.
I got that.
I'm proud of you.
Good afternoon, may it please the court.
I found this to be so interesting.
Apologies, Your Honor. I'm actually introducing Pratik Shah, who's been admitted pro hoc vitae to this court.
I still found it to be interesting.
It doesn't matter who
I'm happy
argues
to
the
just
case.
introduce him and let him sit up and take the argument.
Pot smoking, huh? All right.
May it please the court, Pratik Shah on behalf of defendant appellant Fiorello Pharmaceuticals.
Are you from New York or you're from another jurisdiction?
From Washington, D.C., Your Honor.
Oh, I thought you were going to say Washington State, and then I was going
State.
to understand. Okay, Washington, D.C., okay.
I'd like to
It's a train
focus
ride.
my limited time today on the first question presented.
I'm going to start the
Whether-
clock all over again. I'm sorry, there was that banter.
Sure.
There you go.
Okay, thanks. I'd like
Wait
to
a
focus.
second. Was there covered expenses covered in this agreement? And that's basically it, right? I mean, that's what ultimately what's happening here?
Pardon, Your Honor.
Or the plaintiff is seeking, as part of damages,
Yes.
cover.
Is
what
seeking-
the deal that they had to close with somebody else.
Correct.
And now they want to charge you for it.
Correct, Your Honor. That's
Right.
that's their
about
claim.
it. That's the bottom line. And does the agreement, this agreement, however you want to interpret it, does it call for cover?
No, Your Honor. No one has ever alleged that anything in the agreement could be read to create an obligation for cover damages, and there's certainly nothing explicit about it at all. There's no liquidated damages provision, no cover damages provision at all. This is just like the agreements to agree that the New York Court of Appeals reviewed in Goodstein. It's like the agreement to agree that this court reviewed in 180 Water Street. It's like the agreement to agree that this court reviewed in
Well,
Garda.
it's interesting because the court mentioned Goodstein, and I, was reading it, and I read Goodstein, but then the court kind of distinguished it or attempted to distinguish it, and I wasn't, so what is your position in terms of the application or inapplication of Goodstein?
Sure. Goodstein controls this case, Your Honor. What the trial court did is it cited the alternative holding in Goodstein. What happened in Goodstein is the appellate division said, quote, it's an issue of fact whether damages were fairly within the contemplation of the parties. That's plaintiff's position here. That was the position of the appellate division in Goodstein. The New York Court of Appeals reversed and said, it is a matter of law, and as a matter of law and logic, it precludes the recovery of expectancy damages based upon defendants' anticipated performance as if negotiations had progressed to a final contract. And the reason Goodstein gave is it said, quote, you can't base damages on a contract that defendant was fully at liberty to reject because it would, quote, transform an agreement to negotiate a contract into a contract itself. Goodstein then said, in addition, there's no but-for causation because, quote, even with the best of faith, a deal might not have closed between...
You can't control your shareholders because the shareholders have to vote on this.
Correct.
Right? So you're not going to be able to control what they're going to do.
Correct. The shareholders had to vote on it.
And also the Department of Health, which is even less predictable, I would imagine.
Exactly, Your Honor.
Yeah.
Just like in
Oh,
Goodstein,
yeah.
I mean, this is like on all fours with Goodstein. Just like in Goodstein, there was an agency that had to approve the contract. Here, same thing. Everyone agrees the deal was off if any deal had even been
Well,
reached.
Supreme Court said that the agreement you had here was a little bit more than an agreement to agree. There was just a lot of buzzwords and a lot of provisions in there that, you know, it kind of went beyond the agreement to agree.
So, Your Honor, every plaintiff, if you look at the briefing in Goodstein, in 180 Water Street, and in Garda, claimed that theirs was not a garden variety letter of intent. But this is not a unicorn. In Goodstein, the court said this was an unusually detailed, that's the quote, that's the characterization the court gave. It's an unusually detailed letter of intent subject to a binding good faith obligation. In 180 Water Street, the court said it involved breach of a mutual exclusivity provision. That's the main distinction that the other side draws. Oh,
that's what their breach of contract is now limited to, is the breach of the exclusivity.
Right, and
portion,
we agree.
Right,
that's
not the confidentiality that Supreme Court kind of roped in and talked about in its decision, right?
Right. They say the key distinction between all the lines of cases is this one had a mutual exclusivity provision, but 180 Water Street, as this court recognized, was a mutual exclusivity provision that this court said plaintiffs alleged defendants had breached from day one. It is on all fours with this case. And what did this court say in 180 Water Street? It quoted Goodstein, and then it said that you are limited to out-of-pocket costs. And then the third case, Garda, which the trial court didn't even cite, that's a 2021 decision from this court that both parties cited in summary judgment. That had a binding confidentiality and a binding exclusivity provision. And yet, here's what the court said. Because the documents state the defendants were not bound to go forward with the transaction.
Okay, so let me ask you this question. So even before we get to damages, I mean, you have to have a finding of breach of contract, right? You have to find liability. Supreme Court, sua sponte, ruled in favor of the plaintiff by saying breach of contract, finding a liability.
Your Honor, you're right. It's odd in that fashion as well. I think this court has to resolve both issues, right? Because it's, as it should, if it sends it back premature summary judgment, you can't sua sponte grant summary judgment, doubly so when there are material disputes of fact. But then it also has to decide if a jury were to find a breach, what would be the measure of damages?
Right,
Those
yeah,
are the two.
absolutely, right.
Yep.
Okay.
Thank you.
Okay, thank you.
May it please the court, Stephen Asher. I'm with my colleague Melissa Fedornak from Jenner and Block for the response.
She going to argue for you?
Excuse me?
Is she going to argue for you?
No, I'm just introducing her.
All right. So let me start with the threshold issue. The breach of contract. Supreme Court sua sponte ruled in your favor, found that there was a breach of contract on the issue of liability. You know, because based on the exclusivity provision, right? And then also kind of roped in the confidentiality agreement, but that's not, the confidentiality provision had nothing, that's not your cause of action. Your cause of action was the breach of the exclusivity agreement or provision within the contract, that they were talking to other people after you entered into this LOI, and that they shouldn't have done that.
So I can defend that, Your Honor, but I do want to talk about Goodstein a lot because I think that's where kind of all the marbles are. But our theory was that breach of exclusivity was the overwhelming theory here, and it included breaches of confidentiality and a failure to negotiate in good faith, and that is clearly apparent from the face of our complaint. And discovery was taken on all of those issues.
Counsel, I would really appreciate if you would talk about Garda, because it seems to me that part of what you argued is that this was not just an agreement to agree because of the exclusivity and confidentiality provisions, but Garda, the contract at issue in Garda had both of those, and yet our court limited to them to out-of-pocket damages. So why shouldn't that apply here?
Garda had an exclusivity provision, but that's not what was breached in Garda. And the decision is very careful. There was no conversation or discussion with another party until long after the expiration of the exclusivity period. And that's why Garda is purely a confidentiality case. And let me take a step back to explain why this case is so different from both Garda and Goodstein.
That's what I was asking.
Yeah, it's both of them. This is a case where they used us as a stalking horse. They got us to agree to pay them $32.5 million. They locked us in. They got us to promise that we weren't going to talk to anybody else for 30 business days. And then they went out and they took that piece of paper and they shopped it for a better deal.
Well, when you're saying they got us to, it's not they got us to, you agreed to it, right?
Well, the exclusivity
Two
part,
sophisticated parties agreed.
Oh, the trick, Your Honor, is simply that they violated it literally within a nanosecond of signing it. We signed it with our eyes wide open. We wanted a mutual exclusivity provision. They wanted a mutual exclusivity provision. But they used that to take advantage of my client, to use my client as a stalking horse and to get themselves a better price. They got themselves another $10 million at least. And the effect of that, and it was a reasonably foreseeable effect in a market where there were only 2 New York licensed cannabis companies still available.
Here's the problem, counsel. So let's assume, for the sake of argument, that you got suckered, which is basically what you're saying, right? There's no provision for liquidated damages here. What is the measure of damages other than what we are using in Goodstein?
Your Honor, the lack of a liquidated
out of pocket.
The lack of a liquidated damages provision cuts the other way. It shows that we didn't agree to limit our damages to only $1 million or $2 million or whatever it was. The lack of liquidated damages shows that the parties contemplated damages according to ordinary contract principles.
But
cover is a very well recognized, I'm sorry.
I would posit that because this letter of intent was to be memorialized later in a different agreement that would actually bind the parties and maybe therefore have liquidated damages in it if that's how it was negotiated. Because of that, Garda, which I know you're saying doesn't apply, but there is a holding in Garda that says, based upon this fact that this was not binding, that they were not bound to go forward with the transaction, you are limited in terms of what your damages would be.
Well, the 2 distinctions from Garda, Your Honor, first of all, as I've already mentioned, it's not a stalking horse case. It's not a case where a breach of an exclusivity provision was used to get a better price. The second difference from Garda, which I think made Garda a no-brainer, Garda, there were no agreed upon terms of the transaction. All they had was a letter agreement specifying confidentiality and exclusivity. They hadn't actually agreed on the terms of the deal. And your decision says twice, the separate letter of intent with the transaction terms was never signed by the parties. So Garda is a case where it was an extraordinarily preliminary agreement. It's nothing like here where you had a fully formed deal and express confidentiality and, express exclusivity, which is exactly what they breached. And if you look at all of the cases involving breaches of exclusivity, it's not true that they never grant cost of cover damages. You have Judge Moskowitz's decision in Cerberus before she was elevated to this court. You have multiple cases in Delaware granting cost of cover damages for breaches of exclusivity. And the 180 Water Street decision is a different scenario. In 180 Water Street, part of this court's reasoning was that the lease was too vague to be enforced.
So, counsel, what at some point, the defendants made a counteroffer, right? And they upped their price from, what was it, 22.5 million to 35 million, and that offer was rejected by your client. How does that play into this as far as their coming forth in supposed good faith and your supposed failure to mitigate? You ended up paying someone else for their license like 102.9 million. You're looking for the difference between the 35 million offer that you rejected and the 102.9 million offer that you had to accept.
The difference, according to the trial court's formula, would be between the amount that Cresco paid for Valley minus the amount that Fiorello received from its acquirer. So the terms of our offers are not relevant to the trial court's theory. Second of all, Your Honor, in terms of determining damages, the negotiations that the parties had after the breach and after the...
I guess what I'm asking you is, isn't that the whole premise behind, you know what it is? I always have to look at the names to make sure I pronounce them right. Isn't that the whole premise behind Goodstein, that the measure of damages in such a case as this is speculative, and therefore you're limited to out-of-pocket damages?
This is different from Goodstein because in Goodstein they were seeking lost profits based on the premise that if we had concluded a deal, here are the profits we would have made. We are not seeking lost profits, we're seeking cost of cover. And the cost of cover is not based on some hypothetical projection of what might have happened in the future. The cost of cover is based on the difference between a transaction that we actually entered into and the terms of the transaction that they actually entered into.
Thank you.
There's nothing speculative about it.
Thank you.
Thank you.
So the way I look at it is Garter is, I think, a broad view of Garter says if you have these two provisions, exclusivity and confidentiality in a document, for whatever else is going on, you're limited to out-of-pocket damages, right? So that's like, to me, that's a broad reading of Garter. I mean, you can have a lot of facts, you can have a lot of other disputes going on, but the way I read Garter, since I was there, says, yes, you got these two provisions in there, right away you're damaged, because this is what we're looking at, forgetting about whether or not there's a breach or what, your damages is limited to out-of-pocket.
Your Honor, that's exactly right, and that follows, of course, Garda was following Goodstein, as it must do, New York Court of Appeals decision.
You're kind of checking off the boxes. Are these there? If A, B is there, well, you know what, that's it.
Absolutely, Your Honor. This is a rare case where we actually have a super well-developed constellation of precedents from both the New York Court of Appeals and applied by this very court on almost strikingly similar facts. On the other side, we've had briefing, we've had argument in the trial court and the appeals court. They have yet to cite a single case in the history of the New York Court of Appeals or the appellate division from any department that has ever awarded more than out-of-pocket costs for a breach of an agreement to agree with or without exclusivity clauses, with or without confidentiality clauses. The only case he cited here today was Cerberus. That's a 17-year-old unpublished trial court decision that does not cite Goodstein. If there is any ambiguity at all, 180 Water Street, this court's 2004 decision, resolves it. That had a mutual exclusivity provision, and as counsel said, they say we used them as a stalking horse and we started breaching it from the first day. That is verbatim what the argument was in 180 Water
So you're
Street.
saying, counsel, that it makes no difference that a party would enter into a letter of intent to and violated it almost immediately, that bad faith or in my parlance, sucker punching makes no difference?
No, Your Honor, that means it's an actionable claim, right? If they can prove bad faith or that we breached The exclusivity provisions, they have a claim. It's for breach of the exclusivity provision, and they have damages. It's out-of-pocket costs, whatever the due diligence cost, attorney's fees, you know, those sorts of things. That's what Goodstein held, right? In Goodstein, it said, look, you do have a you have a claim. You have a claim for breach of the good faith
Because
obligation.
if we were to agree with the plaintiff here, we'd be opening up, forget it. I
It
mean,
would undo
it would
30
undo
years
a-
of law, and this goes to your question.
30, much more than that. It would be impossible to ever have an agreement to agree.
Exactly.
You'd have a
and-
line outside this courthouse with all the appeals coming up.
Absolutely, Your Honor. And this goes to your point, Your Honor. These are sophisticated business parties. If the parties truly want a different remedy, right? This is how contract law works. You guys have set up a clear default rule. If sophisticated business parties want to
But if
depart
you did
from
that, it's no longer agreement to agree. If you start putting that kind of language in, the liquidation, damages, default provision, that's a contract at that point.
Right, but they can modify it,
Yeah.
and they can provide for a cover damages
That's not what
provision.
we have here.
That's not what we have here,
okay.
exactly.
Thank you, thank you
Your Honor.
all. Rivera versus Matis Architecture. You did a good job. Very proud of you.
If the court please, Thomas Wilson for Rivera. Rivera is an injured construction worker at 3 Riverside Drive. 3 Riverside Drive is a mansion from the 1880s. 3 Riverside Drive was being advertised as having 4 floors below the basement with a swimming pool and for sale for $14.5 million. It was owned by a corporation, 3 Riverside Drive.
Counsel, the affidavit that was submitted by Adam Zoya, where it indicates that RSD intended to have certain renovations performed to it before he and his family moved into it, how should we view that affidavit?
We have to look at the person that signed the affidavit. Harvard lawyer, lectures, teaches, and invests. Real estate flip projects. How to handle the taxes, how to do them, how to insure them. That's who he is. He's from Massachusetts, Cape Cod. He lives up there, never took possession of the house, never moved in, and in fact, still has never moved in, and the house is still for sale. Price has gone up a little.
All of that you just indicated, that wasn't inside the affidavit. Would that be something that would need to be?
That was not inside the affidavit. What he said was, I own corporation solely. That corporation owns Riverside Drive, and I intend in the future to move there as my house, so I get the exemption.
Yeah, so that's what caught my eyes. He says intend.
Yeah.
Just simply say, I will move into that apartment.
He said he intended to use the property solely for residential purposes.
If you find, and this court finds, that an affidavit before discovery, which is self-serving and made up by the lawyers of the affiant, can destroy the liability of a commercial property being sold and being outside of the single-family residence, then there are no more single-family residences. This is not grandma and grandpa who live in the house and are having their house rebuilt. This is not, we've raised our kids here. He intends to move there, but he's got his cars registered in Massachusetts.
Well, that's my point. I mean, why say intend when if you're going to do it, just say I will or I am going to move in, and that's the
No it's self-serving, no cross-examination, no discovery.
As my colleague said, all the information he said about him being here, there, whatever, it's not in the affidavit, but that's all going to be fleshed out during the
The
deposition.
summary judgment is built on that affidavit.
Well, I mean, at the
That
very least, then your argument is that there are issues of fact.
Yes.
That need to be fleshed out, at least by the deposition, his deposition.
Yes.
And others. Thank you.
Give up the rest of my time.
Good afternoon, Your Honors. May it please the court. My name is Rachel Smith. I represent the defendant respondent 3 RSD. The underlying
your
motion.
client in the affidavit, I thought it was very interesting. He says he intends to do this, he intends to do that, he intends to. Why couldn't he just simply say, I am going to live there, I am going to do this? I mean, why is this intend? Because that leaves me with the impression that he hasn't made up his mind yet about what he wants to do with this property.
Well, the case law that matters is in Farias v. Simon, and the question is, what was the intention for the property at the time of the accident?
Was that on summary judgment that motion was being made?
Yes.
That case, this is 3211. Isn't
This is a summary judgment motion.
This is summary judgment?
But he was there, he hadn't been deposed yet, right?
He hadn't, but the court has
But why wouldn't it be appropriate for him to be deposed so somebody can inquire as to whether there's any merit or value or anything behind this alleged intent to move in, especially given his apparent history of flipping other properties?
Because that's not factually correct. First of all, there's no history of him flipping prior properties. But
why shouldn't this go to, why shouldn't he have a deposition rather than something so amorphous be determined to be impregnable and not raise questions of fact?
The deposition is going to yield the exact same testimony as this affidavit has
Here's
established.
the thing about this
We don't know
affidavit,
that.
and I find that the wording very peculiar, because it doesn't say that I am now saying that I intend. It says that it's removed, right? Like he's talking in the third person for the LLC. 3 RSD intends to have this, to make certain renovations
Well, he's respecting the
before I and my family move into it. Not that I am making these renovations because I intend to. It's really talking about what 3 RSD intends. I understand that they're the defendant here, but I mean, it's not something that without further questioning you could just take on face value.
Well, what I'll say is what the plaintiff put forward to question this affidavit is nothing more than speculation, which is what the lower court decided this decision on. The fact that my client is a lawyer does not make him a real estate investor. We all have law degrees. We're not all real estate
But
investors.
plaintiff did put forth documentation that that 3 RSD had previously undertaken similar projects for commercial purposes, right?
He put forward proof that Mr. Zoya had previously sold a home.
I'm sorry?
He put forward proof that Mr. Zoya had previously sold a home. The fact, 3 RSD owns solely 3 Riverside Drive.
But I thought he put forth documentation that 3 RSD had also had undertaken similar projects in terms of renovations, I thought, for properties for commercial purposes.
No, he did not. That is what the appellant called and said, but that's not what the records he actually cite to say. The interview that he cited to for Mr. Zoya, where he claims that he's a real estate investor, is actually him speaking about a data company that he created, because quote unquote, his statement is that he has worked in data and HR recruiting tools his entire career.
And this property has already been placed on the market, right?
Well, at the time that the accident occurred, which that's what the site and purpose test calls for, it had not been placed on the market. And so what my client does with the property after the date of the accident has no bearing on the ruling of what his intent is.
But
the court
at
decided that
a deposition, that's something that could certainly be inquired about.
it would still result in the same ruling, because the rule is
We don't know that. That's why we have discovery.
his testimony in the affidavit will be the same at a deposition, which is establishing that at the time the plaintiff's accident occurred on February 7th of 2019, his intent was to reside there with his family.
You don't think that a good lawyer could ask him questions that might reveal more?
I've spoken to him, and I don't think it's going to reveal more. Now, my point in this is that in opposition to the motion, the plaintiff had to produce something to overcome the prima facie showing that the affidavit establishes, that the intended use at the time of the accident was to be his primary resident. What he put forward is nothing more than pure speculation.
And you're asking us to assume that, never mind.
Owning a car, owning a home in another town, owning a home previously and selling it, being a lawyer, that's not proof of being a real estate investor. What is proof is the case law that he cited to where somebody had owned 15 homes previously and said, I'm only going to live here for 2 years and I'm going to flip the home. Patino versus Drexler, a case that this court decided in 2014, had the exact same scenario, a labor law 240 case. The homeowner exemption moved by a defendant pre-discovery, and they submitted affidavits showing that while this was the second resident of the family, they intended to only use it for their family coming to town and guests. There's no proof that a business was going to be run from there. There's no proof they were going to have it in Airbnb or whatever. It was a second family home for them, and that was it.
Any significance to the fact that we're talking about an LLC as opposed to individuals? I mean, I understand he's the only member of the LLC.
No,
but we're
there's
still
not
talking
any
about an
significance
LLC.
to that. I would say, I believe it was either Patino or Ferreras where the family had it in a trust. I think it was Ferreras. The family had inherited a home and put it into a trust that multiple people used and multiple people were going to own. I think that the fact that my client chose to put it in an LLC is merely a method used to protect the asset from any other liabilities that my client may be.
An LLC that had also engaged in other projects for commercial properties.
It could be, but there's no evidence that it was. There's no evidence that 3RSD owned anything else.
Thank
What-
you.
I had the privilege of preparing the opposition papers for
Yeah, so
them.
counsel, what documentation did you present to show that 3RSD did in fact engage in other projects?
Listings-
With the commercial,
listings
because
on
your
Z-
adversary stated that that was purely speculative.
Well, what I showed the court in the opposition were Zillow listings, Google listings, Streetwise listings, and also referred to YouTube lectures by this affiant on how to do this,
How to do what?
flip properties, construction.
Is that sufficient to show that was his intent with this particular property, that he was gonna flip it?
I think it's enough for discovery.
And to raise an issue?
I think that the issue is that on discovery, is it a fact question or is it a question of law? That he is going to move in or he intends to move in? He has
But he's
not.
gonna say the same thing at depositions that he said in his affidavit.
Well, but the Zillow showings for sale for $14.5 million while it's under construction, while he's still living in
This particular property,
this particular property.
at the time of the accident or after that?
Actually before and continued. Any place on YouTube, any of the listings, and you can see pictures of what they intend for the swimming pool down on the third basement level and all this, and they were advertising it. In fact, they raised the price on it.
Thank you. Thank you both.
Thank you.
Tavares versus LIC Development.
Good afternoon, Your Honors. May it please the Court. Kevin Fitzpatrick from Woodsmith, Henning, and Berman for the second third-party defendant appellant, Collins Building Services, CBS. This is the second time I appear before Your Honors in this same case.
What does other mean? Because this is your employee who fell off the ladder while doing cleaning or doing something, right?
That's correct,
And
Your
the
Honor.
policy says, you know, you provide indemnification to others, right? Does that cover the employee, right? I mean,
It can't. When you look at the contract, there's no dispute that she's not a tenant, so it could only be, this provision could only apply if she were considered others. Throughout the contract, it is replete with references to personnel and employees of the contractor, which is my client CBS. It never refers to others. But even if the plaintiff were others, this provision would still not be applicable to the facts of this case because the second part of it is that it's claims by others whose personnel or property may be damaged by Collins. There's no claim for property damage by the plaintiff, and she did not have any personnel, nor is there any claim that her personnel were damaged. So there is no way that this hold harmless provision could be applicable to the facts of this case.
well, yeah, because if you were to say the others included your employee here, that second half would fall under the workers' comp. If it's like personnel, whose personnel, I guess person, may be damaged by you, the contractor, that falls into the workers' comp situation, right?
That's correct, Your Honor. And simply put, if the parties intended to have a situation where there would be a hold harmless, for my client to hold Tishman harmless, they would have said so. And this exact situation is addressed in Tonking v. Port Authority, where if there is not explicit language delineating what the parties intended, the courts will not read into it or add additional provisions or language that the parties did not intend to originally have in the agreement. Since that is the sole portion of the written agreement that would be the basis of the contractual indemnification claim, the second third-party complaint should be dismissed. There is also a second claim. There's two causes of action in the second third-party complaint. We asked for dismissal of what appeared to be a common law indemnification claim that this court already issued a ruling last year that there could not be one because there's no grave injury. Tishman claims that they did not allege that cause of action, so therefore it appears to be moot, and therefore we ask for the lower court's decision to be reversed. Thank you.
Thank you.
Good afternoon. Excuse me. Good afternoon. May it please the court. Eric Schlesinger from the law offices of Golden Rothschild, Spagnola, Lindell, Boylan, and Garubo on behalf of the respondent, Tishman Spire Properties, LP.
So, counsel, how do we deal with the fact that the plain language, the plain writing of this seems to say something very simple, that others whose personnel or property may be damaged by contractor, by definition, doesn't include employee?
Because they're not indemnifying Ms. Tavares, who was Collins' employee. My client, Tishman Spire Properties, is the one that's being indemnified because they're being damaged by a claim based upon Collins' improper practices and unsafe conditions. Collins has a duty of care to provide a safe workplace for its employees.
I'm sorry, it doesn't make any sense.
If we have to pay out damages, if plaintiff ultimately collects, then my client's damaged because my client's merely a property manager. This was all Collins' project.
So
they provided the equipment, they provided the personnel.
I'm reading this sentence again now, and it says owners, it's basically indemnifying you, owner's agent, from all claims by tenants, when we don't have a
Right,
tenant
it's not a tenant.
situation, right? Or others whose personnel may be damaged by contract. Others whose personnel, this is an individual employee. She's not a personnel, right?
No, she's not a personnel, but they also make that distinction within the terms of the contract overall is itself ambiguous because it deals with its operators may be damaged by contractor Collins, its operators, and including but not limited to the use of or the required equipment or material. That's what happened here.
Well, see, counsel, I guess, in just following up on what my colleague asked, this particular paragraph uses the word contractor twice, contractor referring to Collins.
Correct.
And it doesn't say or contractors personnel or other personnel. It inserts the word whose and it talks about others, clearly distinguishing from contractor, right? I mean, how else could we read that sentence?
But it's if you look at the overall contract, which the Court of Appeals in Hooper says, if there's a potentially ambiguous reading, you have to look at the entirety of the
I don't
contract.
think it's ambiguous. I think it's actually pretty straightforward.
It's subject to interpretation. But here we are. But that's the ultimate issue. If there's a reasonable interpretation other than what's being put forth by Collins, because they moved under 3211A7, which says they have to utterly refute it. And that's what the trial court said.
Your interpretation reasonable.
Yes. I think our other interpretation is reasonable. And they have to utterly refute it. And the trial court said, no, it wasn't utterly refuted. They failed in their burden. Therefore, it's subject to discovery and the claim goes forward. It's not that I didn't have a cause of action, but it's subject to ambiguity. There's no parole evidence in the motions, but if it can be ambiguous and there's another reasonable interpretation, then I'm entitled to move forward with my claim.
Yeah, but when you say others, the phrase others whose personnel, I mean, you're now saying that the contractor's personnel, the contractor's employee, that's a lawsuit that's covered under this indemnification agreement. As my colleague says, That doesn't say that. It could have said, or other and contractors whose personnel, I mean, at that point, okay, you got it. The contractor's employees, personnel, they sue you, that's covered. This doesn't say that. You can't, you're asking us to read into something that doesn't seem, it's not there.
I understand the court's point. I think there's a different interpretation, especially when you're looking at the other language utilized throughout the terms of the contract, where they specifically identified employees and personnel.
Do you have any citations to cases that have interpreted a similar clause as you're asking us to interpret this?
I have not, otherwise they would have been in my brief.
Oh, we'll be the first.
Thank you.
There's nothing wrong with being an issue of first impression.
Thank you.
And it's gonna
Thank
go
you.
up probably.
Your candor.
We don't send things up.
Your Honors, I'm not sure I have much to add, other than to quote Tom King, if the parties intended to cover the plaintiff in this case, they only had to say so unambiguously. So I don't think there's any other way to construe this provision.
Thank you.
Thank you, Your Honors.
Thank you both. People v. Joseph Montesquieu. Ellen Beach.
Good afternoon. May it please the court. Nicole G. Douglas, Center for Appellate Litigation, on behalf of appellant Joseph Montesquieu. Teenagers who engage in sexual misconduct pose an exceedingly low risk of sexually reoffending. Decades of research consistently show that teens convicted of a sex offense are no more likely to sexually offend in adulthood than those who have not been convicted of a sex offense.
So you're asking us to exercise our discretion and he's level 3, and you want a reduction to level 2. Is that correct?
Yes, Your Honor.
And so you're asking us to exercise our discretion. So why would we exercise our discretion in this particular case?
In this case, the Sora court determined that a downward departure was not warranted because the mitigating circumstance that Joseph had identified, his youth at the time of the offense, was not a mitigating circumstance based on factor 8 of the RAI. Research, however, refutes
Well,
that.
was it only his youth, his age, or was it also the circumstances of the case, of the incident, of the crime, also the fact that his prior criminal history, as well as the fact I thought he was on probation at the time of the incident? I mean, it was more than just his age, wasn't it?
In terms of what motivated the court's denial or the grounds
In
for...
terms of mitigation.
So the mitigation that was put forth, Your Honor is correct, was his age. It was also the attempt nature of the offense, and that it was not...
Well, the attempt nature because it wasn't completed? Is that what you're saying?
Yes, that demonstrated that he did not pose the highest risk.
Well, that's because she said she was 12 years old, right? I mean, that was the argument was that she told him that she was 12 years old.
The argument was that that she made that statement before he ended his misconduct before.
Right, that he followed her into her building, threatened her at knife point, ordered her to perform oral sex on him. When she begged him to let her go, he asked her age. When she said she was 12, then he discontinued his actions. And the entire incident was caught on surveillance. So it wasn't completed in the sense that he didn't continue with whatever he was going to do because she begged him not to when she said she was 12 years old, right?
That is the position that the people took.
So again, given all of these circumstances, why would we exercise our discretion in reducing it from a level 3 to a level 2?
Because the overall circumstances of the offense, even as just described, his age at the time, the family support that he was being introduced into, do not support that he poses the highest risk of reoffense.
So also, please correct me if I'm mistaken, there was an issue in terms of his participation, I think, in a program. One was a substance abuse program. The other one, I thought, was a sex offender program where he was terminated from both or released from both because of non-compliance, if I'm not mistaken.
So as we introduced into the record before the SORA hearing, Joseph did refuse to participate in sex offender treatment. He wrote a note to his counselor indicating that he feared for his physical safety participating in the program as a young man in an adult maximum security prison, and so he did not complete the sex offender treatment while he was incarcerated. And we included in our submission to the court the note that he wrote to his counselor explaining his refusal. And that also was a basis upon which we sought a downward departure, because both this court and the higher court has indicated that circumstances such as that, explanations for...
But the court didn't give him any points because of that. They accepted his explanation and didn't give him, and deleted the 15 points that had previously been assessed against him for refusing to continue with sex offender program, right?
The court did decide to decline to assess points, although that was not what this court has instructed courts to do. Instead, this court...
That's the case that's in front of us, is the court, in fact, didn't give him points for that.
Yes, I was just explaining that what we had sought prior to that was that was also part of the mitigation for a downward departure. The totality of the circumstances do not support the highest risk level in this case, and we ask that his risk level be modified to level 2.
Thank you.
Good afternoon. May it please the court, Jamie Masson for the people. If I may just touch upon Justice Gessmer's question about the sex offender treatment program. It is correct that the defendant did not complete or even begin sex offender treatment for the reasons that Ms. Dial just stated. However, it's important to recognize that below they did argue that it was a basis for downward departure. They did not carry that argument up on appeal, and it is thus waived. And that makes sense, because if an offender has not started or taken any steps in incarceration to complete sex offender treatment, it's hard to make the connection that his risk of reoffending is lower and justifies a downward departure. In any event, I would like to turn to Justice Weber's questions in terms of the record of what the victim did to get away from this defendant, as well as her question for the substance abuse treatment completion. And in terms of the record, there is no indication here that the defendant in any way stopped or truncated his actions due to recognizing the wrongness of his own behavior. What we have here, as Justice Weber pointed out, is a 15-year-old child who was very courageous and basically thought of any reason whatsoever just to get away from the defendant's presence. She succeeded because, in part, she convinced him, seemingly, that she was even younger than 15 years old, that she was 12 years old. But even then, the grand jury minutes make it very clear that the defendant still hesitated in letting her go. He waited another 5 minutes. After he finally removed his hands from her body and let her go run upstairs to her family, he still couldn't help himself. He sexually assaulted her by slapping her buttocks really hard as she was fleeing up the stairs away from him. So that really shows that this defendant cannot control his sexual impulses, even when confronted with somebody who seemingly is younger than 15 years old. And that speaks very loudly as to why the SOAR court here was exercised their discretion quite soundly in denying a downward departure. Finally, as in terms of the substance abuse treatment, this defendant was removed from substance abuse treatment because of disciplinary issues. And I think that, again, speaks very loudly as to why the RAI did not underestimate this defendant's high risk here. He stands before this court convicted of 3 crimes. a SOAR offense, which is the subject of this case here, a sexually violent offense, a felony drug offense, and importantly, a misdemeanor for promoting prison contraband. In addition, he exhibited very poor conduct while incarcerated. He amassed 2 Tier 2 violations, which are not de minimis, as well as a Tier 3 violation, which is of course reserved for only the most serious levels and types of misconduct. So because this defendant has a proven track record of not being able to lead a rule-abiding life, it again sharply undercuts any suggestion that the REI overestimated his risk here. The SOAR court exercised its discretion soundly in this case by choosing not to extend a downward departure. And unless there are any further questions, I would ask this court to not disturb the judgment of the SOAR court.
Thank you.
The circumstances in this case, the totality of the circumstances, when considering even all of the factors that the prosecution relies on, none speak to the impact that the fact that Joseph was 18 years old at the time has on his recidivism rate.
I thought he was 21.
Not at the time he pleaded guilty. He may have been. At the time of the offense itself, he was 18 years old. He had not started his senior year of high school, was living with his grandmother, and he...
Oh, I'm sorry, he was 21 at the time of the board's assessment.
Yes, after he served his full 4-year sentence and was awaiting release that happened a year after that. Joseph's age at the time of the offense is indicative of a significantly reduced risk of reoffense, and to instead classify him as posing the highest risk equivalent of a fully formed adult who has committed a sex offense overstates his risk.
Thank you. Thank you both. Winston-Salem versus Ladder Capital. I'm going to stay with you.
Good afternoon, Your Honors. Arash Baral of the State Bar of California, representing the appellant. Pleasure being before you.
Somebody else was from California.
I heard we've got 2 California lawyers here
And,
today.
and the other gentleman that was from California as well. Okay, good. Yeah, you guys can fly back on the same flight.
I've got the 8 o'clock flight tonight out of Newark. So.
Washington, D.C. That was the other
Compare
one.
notes.
Everybody can fly back. Have a good time.
May it please the court. I had a long argument here today, but I think I heard Justice Gesmer in the first case before the court today involving the election law issues say that if the trial court didn't decide something, we send it back to the lower court. And a lot of the issues...
We have a decision here that came
Yeah,
down,
exactly.
right? That kind of
You do have a decision.
perspective everything that happened, right?
You do have a decision.
I mean, to be fair to Justice Reed, I mean, he didn't have the benefit of our decision when he made a ruling here. I mean, I went to look at A, B, C, D. They look pretty much the same in the other case to this case.
I agree, and what I was referencing is the new arguments that Ladder brought up on appeal that weren't decided by Justice Reed in the lower court. So as to the primary issue, which is the reading of Section 1112 of the loan agreement, I believe it should go the same way.
You're only pursuing, the way I look at it, on appeal, you're only looking to pursue first and second cause of action. The third and fourth, good faith,
Correct.
That's not part of your
Yes, Your
appeal.
Honor.
So,
Yes, Your
okay.
Honor. We're only trying to be consistent with the court's
Well, that's
initial ruling.
good. Thank you.
Especially since I was on Ladder, so I appreciate your vote of confidence.
Absolutely. So on that, I'll reserve
Trust
some
me, she
time.
never
on
doubts her position.
Justice Gesman was on that case, Ladder as well.
I believe so.
Both never doubt her decision. Thank you.
Thank you.
Good afternoon, Your Honors. Morgan Fiender, Polson PC, on behalf of the defendant respondent, Ladder Capital Finance.
So what do we do about Ladder?
We even talk at the same time.
Especially when you have 2 of them from the other bench.
Yes, Your Honors. I have to correct a statement that my adversary made. They were not raised for the first time on appeal. They were fully briefed in the Supreme Court. In our motion to dismiss, they were opposed, and they were briefed again in our reply brief. Now, this court is empowered to come to a decision and affirm the Supreme Court based on anything in the record. It can determine that the Supreme Court was correct in dismissing the complaint based on any of the other arguments that the Supreme Court could have considered at the time.
Yeah, but that prior decision, I read it. It was pretty, I mean, I read it, this paragraph by itself when it talked about A, B, C, D, and I had to go and make sure that the A, B, C, Ds in that case were the same as the A, B, C, D that's being alleged here, and they're virtually identical.
Yeah, I mean, you argue that latter is not directly applicable, but you don't really say how or specify why our interpretation of the agreement does not apply here.
We believe it does not apply in this case because these are completely different parties. This is a completely different set of facts. There are other defaults at issue here. There are other issues that were raised in our motion to dismiss that, regardless of the decision by this court in that matter, which we are not arguing here today with.
Right, but as my colleague just stated, the agreement was the same. It's the same agreement.
That's correct. The agreement was the same. The underlying facts, however, are different. These are different parties. And as we asserted in our briefing here and at the Supreme Court, the appellant doesn't even have standing to bring these claims on behalf of the parties to the actual loan documents that we're arguing about here.
Why doesn't it have a derivative standing?
The appellant is not a borrower. The appellate did not plead demand futility as required. They're bringing the suit derivatively on behalf of the borrowers, which are the actual parties to those loan documents.
They asserted a reason for why demand would be futile, and it's why isn't there a reason for viewing a demand as futile a sound reason?
The demand futility must be considered under Delaware law as a state of incorporation of the borrowers. And under Delaware law, they have to plead with sufficient particularity, which they did not do in this complaint. They conclusively stated that based on an internal conflict between all of the various affiliates and managers and other entities, that it would be futile. They did not plead any specific facts to support their position. And they tried to do so in the opposition to the motion to dismiss and tried to do so again in their reply brief here, but none of that.
Why is it insufficient where they allege that the owners, Holdings, Hirschman, Payne, the trust of the manager of the borrowers were the parties that engaged in the transfer, which was the basis of the lender's claim that the borrowers defaulted?
It's not sufficient particularity. They have to, and under Delaware law, an internal conflict actually promotes serving a demand. They want internal resolution.
It's not just an internal conflict. They could be held liable for that action.
They did not assert that in the complaint. It was not sufficiently pled in the complaint, and they cannot remedy those deficiencies in the opposition to our motion to dismiss or on appeal. The particularity requirements must be viewed as they are actually pled in the complaint, and here there is really just one conclusory paragraph stating that it would have been futile because of this purported internal dispute because they didn't think that the managers were doing a good job anymore.
But they were the parties that were engaged in the transfer, which was also the basis of the lender's claim that the borrowers defaulted on the loans. So therefore, I'm not understanding why that is not sufficient.
They didn't plead that sufficiently in the complaint, and there's also a different default that we're talking about here that we raised on our motion to dismiss in the lower court that has nothing to do with the transfer and that separately entitled the lender to foreclose on both of the hotels.
Okay, so this is what the complaint alleges in this case here. WSRI has not made a demand on PHWS to approve the filing of this action because such a demand would be futile. As detailed herein, not only has it's pretty extensive in terms of these few sentences that they're saying here, and in fact, it would be futile because PHWS has filed a petition for judicial dissolution of the WSHH, claiming that the members hopefully can no longer work together and are deadlocked with no method to break such deadlock. So why can't that sounds like futility, because if the guy is suing you to dissolve the thing, he's not going to listen to you when you make a demand. I mean, that's a big deal that they're suing for judicial dissolution. The other member, the 5% member, is suing the 95% member saying marriage is over.
You're correct. That is what is pled in the complaint. And under Delaware law, we don't believe that that is sufficient particularity with respect to the demand futility. Again,
How much more do you need on the Delaware law to say the marriage is over and I don't want to talk to you anymore?
it's supposed to be pled like fraud under Delaware law. So it's
Sorry?
I'm sorry?
it's to be pled like a fraud claim, as would be under Delaware law, with heightened particularity.
Counsel, you referred to another default. I assume you're referring to the franchise default?
That's correct, Your Honor.
Except that under the contract, a franchise default only constitutes an event of default if it's incurable. And there was no allegation in the complaint that the franchise default was incurable. In fact, the allegation was that it was in the process of being cured. So how can you argue at this point that that was an event of default that justified your client's action?
It was an event of default that entitled the lender to foreclose in the hotels pursuant to 2 other court orders, both in Indiana and in North Carolina. Those courts both
But
determined...
under the contract, it wasn't an event of default because it wasn't incurable, right?
Under the franchise, under the loan agreements, they were not entitled to cure other defaults. The event of default was automatic, and they were not entitled under the loan agreements to cure that default.
So with respect to your particularity position, they very smartly put a footnote saying, go look at the verified petition in paragraph 97 in the Delaware Chancery petition. So I bet you dollars and dollars, if I go look at that, it's going to be pretty specific as to what's going on there. So those allegations are going to be incorporated in here by that footnote. So there goes the detailed analysis or further particularity, I would think.
Respectfully, Your Honor, even if you get to the bringing standing, we still don't believe they've stated any claims based on the franchise default and the failure to state any breach of contract claim with the required basic elements of that claim. So even if they do have standing, they didn't plead correctly for a breach of contract claim.
Thank you.
Thank you.
I think as the court already cut on, there is a substantial amount of facts detailed in the complaint about demand futility. It goes outside of the judicial dissolution. It goes to a variety of factors, which I can get into, but I don't think it's necessary to take up the court's time on that. You know, as to the franchise default, as Justice Gesmer pointed out, it does not constitute an event of default under the loan agreement. Therefore, it did not enable Ladder to foreclose under that basis.
What about the fact that 2 other courts in various other states said that that was an event of default?
Well, that's because the manager who they sued the borrower in those 2 other courts, not us, and the borrowers did not seek counsel and they defaulted in those courts. So you have these proposed orders or judgments that were created, I believe, by Ladder, and the court signed off on that. Those are erroneous. The franchise defaults were on the face of the loan agreements. They were, so long as they are incurable, that's when they constitute an event of default. That's not what happened here. Regardless, we're on the motion to dismiss stage. We're on the pleading stage. There's no facts, evidence concerning any franchise default. This is an argument that was raised in the motion papers for the first time.
It never ceases to amaze me, these commercial transactions. The guy that has the most interest can't control what's going on. The guy that has the least interest, it's like a tail wagging the dog. You got a 5% interest holder who's literally running you through the ground.
Well, it gets even worse.
Well, that's what it's alleged. I'm not saying that's happening.
It gets even worse because as to going back to demand futility, we asked Ladder to enable us to take over as the manager of the entities. They said no. So they handcuff us behind our backs.
Didn't they say you got to give me $500,000?
Yeah.
Oh, no.
You gotta,
Say no.
you gotta
They
pay
didn't
us.
say no.
They didn't say no. They said it's going to cost you $500,000.
Yeah,
No, actually,
it wasn't a hard no.
It wasn't a hard no. It went up to $1.5 million, actually.
After we paid them $1 million already.
Yeah.
But it's still that they still didn't say yes. They just said give us more money. So they handcuffed us behind our backs, and now they're claiming you can't really bring this lawsuit.
Tail wagging the dog, but okay.
Thank you. Thank you
everybody.
both. Reeves versus Associated Newspapers. I think you should.
Good afternoon, Your Honor. John Golashevsky on behalf of the appellant. May it please the court. This court has at least 2 independent avenues to reverse the decision of the IAS court. The first is to ask whether any court in New York has ever considered screenshots of text messages, unauthenticated audio, and unauthenticated video To rise to the level of documentary evidence under 3211A7? And the answer, as we lay out in our papers, is of course it is not.
Was there any denial as to authenticity in your papers?
Denial as to the authenticity.
Yeah, of the text messages or the video, like they were doctored or in any way.
We did not get into whether or not they were doctored or not. Our position is that under Grucci, we'll take the audio recordings. The predicate for admission of tape recordings and evidence is clear and convincing proof that the tapes are genuine and that they have not been altered. Here, there was no attempt to offer proof about who recorded the conversations, how it was recorded, or the chain of custody. The audio and video recordings based on Grucci alone are out. They cannot get into it. They say on reply, well, Mr. Reeves never denied that it was his voice. Well, whether it was his voice or not, that's not the question. The question is not whether they had been altered. They flooded this record on a 3211 motion with audio and video.
Well, no, I think what my colleague is getting at is that if they were substantially true, then it would not be actionable.
But our point is that you do not get to that point. They are the proponent of this evidence. They cannot sort of end run around their burden of proof by saying that now we have to deny each and every audio and video recording attached to a motion to dismiss. What they could have done very clearly is they could have gotten the alleged recorder of the audio and the video and the text messages, Miss Michelle, Mr. Reeves' ex-wife, and asked for an authenticating affidavit.
The text messages are different, though. Those were all based on Mr. Reeves' phone number, right?
Well, but the need of an authenticating affidavit is that there must be certain testimony which says, among other things, that they have not been altered. Yes, there is a phone number on a screenshot of a text message. We don't deny that, but that's not the question. If you look at the Fourth Department's decision in the Tucker case, there are 5 or 6 boxes that the Fourth Department said, well, we're going to check this box and check this box and check this box. This is why text messages are getting in. Text messages, quote, that were directly downloaded from each phone. Text message logs of the wireless service providers for both phones. We don't have any of that here. We have screenshots of text messages that were provided to the Daily Mail by Mr. Reeves' estranged wife. So that is the problem with all of this information.
I'm not understanding why is there a difference between screenshots of text messages, which again are substantially true? Why is that not? Why is that actionable?
Because it doesn't rise to the level of admissibility. Who is the other? We don't even know who the other person on the other end of the text message is. Mr. Reeves' former wife does not say that she was the person on the other end of that, does not say that they have not been doctored. All of this indicia of reliability that the Fourth Department sets off in Tucker, they have none of it. And the reason they don't is because they could have gone to Ms. Reeves and they could have asked for an authenticating affidavit.
So, counsel, I am confused.
Sure.
I have to tell you. So here we have I'm going to call it a publishing entity, all right, a newspaper entity, a media entity.
Sure.
And we know that the fair report privilege is quite expansive and that it encompasses reporting on allegations in judicial proceedings. And we know that the indicia of that has to be not 100% accurate, but substantially accurate. And if it's a fair and true report, the privilege works. The privilege applies, and it's not defeated by allegations of malice or bad faith. We know all of that, right? So what are you asking for? You're asking for an additional layer of authenticity to be provided before there's publication?
I'm not. On the issue of authenticity, that is an issue of evidence. What has happened here with the IAS court has been an end run around the rules of evidence. None of this information would withstand a basic motion in limine. None of it would, because they don't have an authenticating affidavit and it doesn't check all of the boxes they're supposed to.
But you're asking us to, no. But you're asking, you're asking us now to impose on the media, on the press, a requirement that they have to make sure that what they're relying on is going to be admissible in court. Is that's somewhat that's along the lines of what you're seems to be suggesting?
It's not. What I'm saying is that today, on a 3211 motion, They may be able to, during discovery, get information that supports, that can authenticate that information. What I am saying is that under 3211A7, this information does not rise to the level of documentary evidence. That's all
Yeah,
I'm
that's
saying.
what I'm saying. Well, that's what I mean. That's what your argument is. It doesn't rise to the level of documentary evidence. That's another way of saying, well, you know what? They better be relying on evidence they better be relying on documents that are going to be passing muster under another analysis. And I can see the prior restraints arguments coming flowing from that.
Well, with respect, there is no
from the media company.
They're
going to go absolutely bonkers.
There is no carve out for defamation cases when we're talking about 3211A7 and what
I'm not saying there's a carve out. I'm not trying to say that there's a carve out. You're asking us to impose another level of some sort of whatever they do in terms of their writings. Now you're saying that they need to do something. If they're going to do a 3211A7 documentary, that document had better be past evidentiary muster.
Well, the fair report privilege protects, with respect, Your Honor, it doesn't protect fair and accurate reports of allegations. It protects fair and accurate reports of proceedings.
Well, let me ask
Not
you,
just.
hold on. Okay, so just in terms of that, because is your argument previously right now towards the audio and text messages? Because we do have other reporting from the proceedings, right? There was a complaint that was filed, there were certain allegations taken from there, there were police reports filed, there were certain allegations taken from there. So are you distinguishing those, or are you lumping them all together?
I'm distinguishing the audio, video, and text messages as one. We said, well, I do not believe that the arrest reports and certainly the letter addressed to whom it may concern from an ADA rises to the level of documentary evidence. There is no authority for that whatsoever. So there's two issues, and they are related. One issue is on the authenticity of all of this information, that they could have gotten an affidavit and they didn't, and the reason we lay out what the family court thought of Mrs. Reeves and the scathing indictment of the misrepresentations and mistruths that she was spewing over 6 years in the family court proceeding. Judge Richardson got to observe this for 6 years, and in awarding custody to Mr. Reeves, he indicted exactly this sort of dishonesty that is going on here, but it is related to the fair report privilege.
And counsel, when you refer to the documentary evidence, is that not the statements, the actual documents that were the basis for the alleged defamation?
Well, there's a distinction. The text messages, the audio, video, absolutely not. The defamation claim, which the IAS court said, well, he attached these, quote, what Daily Mail referred to as court documents.
Right.
There is no question that he attached certain online postings wherein he was alleged to be all matter of ungodly things, which he then sued her for. Our problem is that if you want to fair and accurately report on the defamation proceeding, they were entitled to do it. That's fine. But that's not what they told their readers. What they told their readers is that they were going to hear about a vicious custody battle between a child-abusing, domestic-abusing, drug-addicted neo-Nazi. And when it turns out, the fact of the matter is, Miss Reeves paid somebody thousands of dollars to smear Mr. Reeves, and he subsequently sued her. That is a fair and accurate report of the proceeding. You do not get a fair and accurate fair report privilege based just on reporting on allegations. And the IAS court...
So in reading the article, which is part of the record, right?
Yes.
Okay, so paragraph after paragraph refers to the court proceedings, in the court proceedings, allegations made, and so on and so forth. And then what you have is a context and a headline that reflects on the arrests that the husband underwent, and so on and so forth. The references were very, I'm going to carefully use the word objective because but they appeared to be objective. They appeared to reflect on what actually was happening in the court. So I don't get you.
But if I may, Mr. Reeves was arrested after threatening to kill his in-laws outside the Carlisle Hotel, and that charge was dropped after he agreed to enter into an order of protection. One false statement.
That's a big if, but the arrest was real.
I'm sorry, Your Honor, it wasn't. He was never arrested for issuing any death threat to anybody. It's not accurate.
He received an ACD to cover his cases.
Yeah.
Is that what you're saying?
No, I'm saying he was never arrested for threatening to kill anybody. There was absolutely arrest after arrest after arrest. There was one order of protection on one of them, not on any of the others, on one of them. But you
do agree that an order of protection or in ACD can be all-encompassing and include a number of charges and a number of arrests and so on. That is what happens with ACD.
Do I agree that it could? Yes, that's not what occurred here. And here is the thing.
So you're saying that it was fictitious, it wasn't true that he was arrested outside the Carlisle Hotel?
That's absolutely false. He was not. He was not arrested for issuing death threats to anybody.
Was he arrested at all?
He was arrested on 6 occasions.
In front of the Carlisle?
No, never. He was arrested on 6 occasions, as we lay out, as part and parcel of a $4 million extortion scheme. That's what went on here.
Oh, you have time on rebuttal.
Okay, thank you.
May it please the court, Kelly Sager for the respondents, Associated Newspapers, and Annetta Constantinides.
So, counsel, the appellant here is pushing the point of the authenticity of the documents. You got a 3211A7 motion, documentary evidence, and he's questioning the authenticity, saying that that's not good enough for you to get dismissal of the action because everything that you relied on is all sort of like, it's not evidentiary proof. It's not good evidence, right? What's your response to that? I don't think
that is their argument, Your Honor, and it's understandable because when you look at the actual documents, Mr. Reeves and his companies clearly lose. So his only avenue for any kind of relief here is if the court disregards all the documents we presented to the trial court.
But the one point I wanted to get across to you is that my understanding of the Civil Rights Law 74 that we're dealing with, it talks about fair and true reporting. It doesn't really talk about the documents that you have to do. As long as you manage to hit the mark in terms of your article is fair and it's a fair and true report, you're covered. I mean, regardless of how you get to your article or how you prepare it.
You're correct, Your Honor. There's no question that the documents that are court records, the arrest records, the DA's letter, Mr. Reeves and his counsel have never questioned
the text messages.
That those are actual court documents and arrest records.
The photographs of the text messages, all that, right?
They've never disputed the authenticity of those documents either.
But counsel,
Nor have they claimed that the
with regard to the audio recordings, the affirmation of counsel that seems to accompany them says things like, attached here to is Exhibit 16 is a true and correct copy of an audio recording of a conversation between Carl Reeves and Julianne Michelle on a certain date. Are you claiming that that's an adequate means of authenticating a video?
Well, let's talk about the video and specifically, Your Honor. I'm glad you mentioned that because we do present the court with an affidavit of Julianne Michelle, where she not only references the video and she presented it in court, but she also says she took the video. So her affidavit says she's the one who took the video of Mr. Reeves allegedly taking drugs, and that affidavit is in the record, and I can tell the court precisely where. Mr. Balin's affirmation talks about the court records and arrest records and so forth that are official documents. And there's no question that those are official documents, and there's no question that the article fairly and accurately reports what's in those documents.
Well, here's an easy question. In reference to the documents and materials that your adversary is speaking about, are there any materials or documents there that were not part of the court record that you gratuitously put into the article?
The documents that were not part of the court record in the defamation case or the other proceedings that are only part of the custody proceedings, Your Honor, the videotape and audio tapes and text messages, those were things that were presented to the court in the custody dispute. And Ms. Michelle's affidavit talks about those records that she either obtained.
What about the arrest outside of the Carlisle Hotel, which did not take place, which was reported?
Mr. Reeves was arrested, and he was in fact arrested on one occasion, in part, among other things, for having made threats against Michelle and her parents. He was not arrested because of the threats made in front of the Carlisle Hotel. The parents did file a
your adversary stated that he was never arrested in front of the Carlisle Hotel.
He was not arrested for that particular incident.
No, I thought he said he was never arrested, and there were no arrests of Mr. Reeves in front of the Carlisle Hotel.
There were no arrests in front of the Carlisle Hotel. That is correct. He did threaten Ms. Michelle's parents in front of the Carlisle Hotel. They filed a police report and filed a family offense petition, which the article references. He was arrested on another occasion for threatening her parents.
So he was arrested for making threats in front of the Carlisle Hotel.
Not for making threats on that occasion, Your Honor. He was arrested for other occasions, another occasion when he made threats.
So,
And he also,
bottom line, is this not misleading or at least untrue?
It's substantially true, Your Honor, which is what the trial court found, that he was arrested for making threats. He was arrested on multiple occasions. There were police reports and other records of him having made threats for the incident in front of the Carlisle Hotel. The parents filed a police report. The mother filed a family offense petition, which is what the article relies on. So the fact that he wasn't arrested in front of the hotel on that occasion doesn't make it substantially or materially false. It was substantially true. And one of the arguments we make, Your Honors, which is never addressed by Mr. Reeves and his counsel, not in the trial court and not in this court, is the incremental harm doctrine, which New York courts have routinely recognized that if there are enough statements that are not actionable, either because they aren't challenged or because they're not actionable for other reasons, then the fact that there might be some minor falsity or some minor discrepancy does not give you a cause of action, because everything else essentially is what's causing the damage. That's very relevant here for a couple of reasons, not only because of the Carlisle Hotel incident, but also because of the allegations related to the text messages, the threats, and the drug use. If you look at the complaint, and I've read it now multiple times because I had a hard time believing this, Mr. Reeves never denies the truth of him using drugs. Nothing in the complaint says it is a false statement to accuse him of having used drugs, or even to accuse him of having used the particular drugs that are referenced in the article.
And we know
He
that
never
truth
says
is
that's
a
false.
complete defense, right?
I'm sorry?
We know that truth is a complete defense to a defamation action.
It is, Your Honor, and it's his burden to have pled and to be able to prove the substantial falsity of those allegations. He doesn't allege that they are false. And I would tell the court that the case that I think is really relevant on this part is the Carmen Rodero's case from the Southern District of New York in 2017 involving Dow Jones. And they talk about a guy who the article said was being investigated and was sort of the main person being investigated. And the plaintiff doesn't deny that he was investigated. He sort of talks around whether he was the main subject or not, but he never actually comes out and says, I wasn't investigated at all. And the court said that's basically admitting that he was investigated, which is what the trial court says here. You have these things that Mr. Reeves is accused of. He never denies that he actually did them. He says, well, there's not a court record that says that I used drugs, or the text messages were not part of a court record. He never denies having sent the text messages, which matched his telephone. He never denies that he uses drugs. He simply says that he doesn't agree that there's a video of him using drugs, but he doesn't deny that he used illegal drugs. He doesn't allege it in the complaint, and he doesn't deny it. And he submitted an affidavit to the court in this case where he does make certain factual allegations, but he doesn't address those things at all. His lawyer does an affirmation where he attaches documents, but he doesn't address the authenticity of the text messages, the authenticity of the video and audio evidence, let alone any of the court records, the arrest records, and the other documents we attached. Those are unassailable. It is easy for the court to verify, by judicial notice even, which Mr. Reeves' counsel says the court can do, that those court records are exactly what they purport to be, that the arrest records are exactly what they purport to be. And Mr. Balin's affirmation says these are genuine court records and arrest records and so forth. And there's nothing from the other side.
Could you address the headline as to whether it was sensational or substantially inaccurate in any way?
I'm sorry, for the
headline of the article.
The headline, actually, the fact that if it's sensational, that actually doesn't take it out of the fair index protection. The cases we cite say that. It may be sensational. It may be attach and grabbing. That's kind of what a headline does. But does it actually summarize fairly what's in the article? And Mr. Reeves says, well, no, because it's only about the custody dispute, but the article covers all ground. It covers the custody dispute, it covers the defamation claim, and all the documents that Mr. Reeves' counsel chose to put into evidence or put into that complaint in that case. And all of those things are encompassed within the headline. And one of the cases we cite to the court, the BVD case says, the Cummings case says that even something saying that a teacher walked on students, which is what the headline said, was not taken out of fair index privilege, even though what actually happened was that she pushed them with her foot. And the court said, basically, that's close enough. The headline may be sensational, but it's close enough to get you the protection of the fair index privilege.
Thank you.
Thank you.
It is not Mr. Reeves' burden to detail every piece of evidence or information that they flood a record with and say, that's wrong, that's wrong, that's wrong. It is the burden of the proponent of evidence at any time, including at trial, but especially on a 3211 motion, to demonstrate that it is authentic, and they have not been able to do it.
You're saying that that the documents that they rely on to create this article is not authentic. It's not good enough.
That's exactly right.
That's it. But that's not the Civil Rights Law 76 doesn't require that. It just says, as the way I read civil rights law, unless I'm reading it wrong, basically said it's a fair reporting requirement, right?
But I think we're talking about two different things, Your Honor. On the one hand, we're talking about a fair report privilege. On the other hand, we're talking about what they can rely on a 3211 motion.
Well, how do you get the fair reporting if they can't rely on something?
Again, it is their burden to prove admissibility of this. They could have gotten an authenticating affidavit from Miss Michelle. Why didn't they? It's quite obvious why they didn't.
So the fact that it's...
Affidavit from her.
No, there is a 5-year-old affidavit. She does not attest that it has not been altered. All she says is that I took some video. She doesn't say it's complete. She doesn't say it has been altered. It does not meet the indicia.
But if your client is not denying that the authenticity, then why is it even an issue? He could have put in his affidavit that everything is made up. I didn't use drugs. That's not me. That's not my voice. Do we have that here?
Counsel's position that Mr. Reeves has never denied using drugs is hard to get my head around. He's never sued for defamation for them saying he used drugs. We have 12 different sentences of defamation. Not one of them is, they accused me of using drugs. That's not the issue. It's a total red herring here that has no bearing on anything. And if you look at the Hogan case...
You're asking us to say that they're not entitled to dismissal because they haven't given us... There's nothing in the record to authenticate the documents they used to write the article.
I'm saying that the documents that they presented on a 3211 motion does not rise to the level of documentary evidence. That's all I'm saying.
Those are the documents that form the alleged defamation. That's what I don't understand.
No. There's two separate tranches of documents. One are the articles attached to the defamation case. Now they have switched during litigation and said, well, we were really talking about everything. That's not what the headline says. The court can read it for itself. The other documents are documents provided to them by Michelle, which are all of these unauthenticated documents, screenshots of text messages. They're two totally different tranches of documents. And if I could point...
Wait, but how many articles we're talking about?
One
article.
One article.
One article, okay?
Yes.
So how many documents were used to filter into that one article?
We don't know.
2 sets. We don't know? Let's just say it's the unauthenticated documents that you're pushing. That the unauthenticated documents are the ones that they relied on to write this article, correct? So you're going to ask us now on a 3211A7 motion that you're going to say that that is not sufficient to warrant dismissal of the complaint because it's unauthenticated, which means then, logically speaking, is now you want to elevate their evidentiary value, or you're imposing on them an evidentiary rule of authentication in order to succeed and prevail on the 3211.
There are rules of evidence in defamation, and they apply everywhere else. And if I could direct the court...
But this, we're dealing with a little bit of difference here. We're dealing with Civil Rights Law Section 76, which I think is a little bit different from what you're saying, that this is not a standard, this is not non-media.
Your Honor, with respect, the fair report privilege does not have a carve-out that media groups can somehow use certain documents. That's not what it says. The fair report privilege, and let's be clear what the Hogan case says in the 4th Department, the fact-intensive nature of a fair report privilege. They don't just get it because they're a gossip magazine. They may be able to prove, they may be able to demonstrate in discovery that these items are authentic. They may be able to meet their burden and get it in and get past the motion to eliminate. Maybe. But if you look at the Hogan case on the fact-intensive nature of the fair report,
not that I read the newspaper, but what about the National Enquirer?
Well, this is what we're talking. The Daily Mail is the National Enquirer.
Yeah, okay,
we're talking about the same
they
thing.
Should be, how many lawsuits we got against the National Enquirer that actually prevails and succeeds?
Wait, if I may, Your Honor, quickly.
I'm just making a point.
From Hogan.
Not that I read the National Enquirer.
A reporter's failure to credit the flat denial of charges by plaintiff's father before publication, or at least investigate it further, and the ready accessibility to him of the means to determine the truth of the claim of arrest, persuade us defendant's conduct should be judged by a jury.
I went line by line on your 12 statements, allegations, and so on. And I have next to one like domestic incident report. This one is from the disposition in the criminal proceeding.
It's not all of them. And I accept the fact that on certain of these statements, they're talking about arrests. But to your Honor's question or statement earlier, which they have a fair and true report privilege on allegations, they don't. It's a fair and true report of official proceedings. The proceeding of Mr. Reeves' arrest is not that he was arrested. That's not the proceeding. The proceeding is that he was arrested and then every charge was dismissed because they were fabricated. That is a completely different story. And if
You're saying there had to be a follow-up article.
No, I'm not saying it has to be a follow-up. I'm saying they have to do their due diligence before they publish.
They have an arrest report.
Excuse me?
They have the arrest report.
And it's a
they
fact
have
he
the
was arrested.
disposition that he received an ACT.
And if I may direct the court to the New Jersey Appellate Division.
Forget New Jersey, they're across the street.
York.
This is New York. Well, let me ask you
I
one
understand,
question.
but in the
Let me ask you
Gillian
one question.
case.
Let me ask you this question. Civil Rights Law 76 is what we're dealing with here, right? That's the absolute privilege. 74. 74, okay. The civil rights law that we're talking about gives them absolute privilege. You're saying now that you want us to impose, or at least read into that Civil Rights Law 74, a requirement that there be an if they authenticate the documents in order to get that privilege or get that privilege.
Media organizations get sued all the time, and they are protected by the fair report.
That's my question. I asked you a very simple question.
I'm not saying that. I'm not saying that. And not every media organization that is sued in New York Supreme Court has to turn around and flood a record with dozens and dozens of exhibits
I'm
like
just
that.
asking a simple question. Are you asking us to impose onto that statute a new requirement that if you're going to rely on this statute to dismiss a case based on documentary evidence, you must have it authenticated?
No, I don't.
But that seems to be the natural result.
Well, I'm not asking for an amendment of any statute.
I think Judge.
No, you're not asking for an amendment. You're asking us to read into the
One last question,
I have a different question, following up on Justice Gonzalez's question. I went through the 12 or so elements that you claimed were defamatory, and it seems to me that each of those could be tied to some document other than a text message or video. Some of them could be were based on the DA's letter. Some of them were attached to documents attached to your client's lawsuit, based on the arrest documents. So really, I don't see that any of their claims actually rely on the text messages or the videos.
I disagree. If you go through the trial court's decision on many of these statements, and we can pull it up if we have the time, on many of these statements, they say, well, maybe it's fair report, but let me look at the video. And there are text messages, and there are video. That's what the IAS court repeatedly says, repeatedly relies on that, and that's in the order.
Thank you. Thank you both.
Thank you.
Last case for argument, Paulson v. Paulson.
Good afternoon, Your Honor. My name is Robert Cohen, and I'm here for the appellant, Mrs. Paulson. The underlying case involves a 20-plus year marriage. During that marriage, the respondent, Mr. Paulson, put the preponderance of his assets in 3 trusts. Those trusts now have a value of over $4 billion.
I'm sorry, $4 billion?
With a B.
Billion.
With a B.
With a B.
Just checking.
I had that correction downtown too. Someone said to me with the B.
Those assets are the great preponderance of the marital assets in this case.
So, counsel, the Supreme Court relied on its closure order on the fact that both sides agreed to seal all the documents and said, well, you know, and I read the transcript, you know, why I should close the courtroom, because if I don't close the courtroom, the sealing order would be for no, I mean, it doesn't work that way. I mean, how do you respond to that kind of analysis?
Actually, and respectfully, the court below relied on 7 documents that we had agreed would be sealed.
Right.
And frankly, in a matrimonial case, all of these documents would be sealed because we all know that the files are sealed.
This is not a matrimonial case.
This is not
Plenary action.
This is not a matrimonial case.
So my question is, where in the law does it state that you can seal a courtroom because there are confidential documents?
Where,
I mean, I couldn't find any precedent to do that, where because you have confidential documents, then you would carve out an ability to seal the courtroom.
well, to answer your question, Judge, I think parties can agree on taking constitutional rights, and they can agree on waiving those constitutional rights. I think they can agree on waiving the right to have public documents. I'm not sure that's really the issue here that we have here. The issues we have here, by the way, Judge Owing, the document that you just referred to is an order of Judge Knock. And what Judge Knock says at the end of that order, this is without prejudice to anything else that would happen, any other sealing of any other documents. He took that order that he entered and then used that as the reason for stopping, for closing a trial in this case.
Well, it's not even the closing. It was an argument on a summary judgment motion, right? It was an argument, or was it?
It was never an argument. Well, let me talk to the court, if I may, about what happened here. The night before the court was to hear argument, or the afternoon before, an associate at Blank Rome called the court, ex parte, no knowledge of our office, no prior advice. The judge picked up the phone and talked ex parte to the associate, and the associate, and this is according to what Judge Knock reported, and it's in the transcript, Judge Knock said, the associate said, we want to close the courtroom for the argument tomorrow.
There was no motion, am I correct?
Sorry?
There was no motion.
There was no motion. We had my office had no idea that anybody wanted to close this courtroom. So Judge Knock takes the call, finishes the call. As you all know, having been Supreme Court judges at one time, you wouldn't get on the phone unless both sides are ready. Judge Knock erred, took the call, listened to the report, and then we never knew about that call. The next morning, we're on a calendar. It's a 9:30 calendar. Our office is ready to argue the motion with no sealing, no closure, nothing like that. We're getting ready to argue the motion, as is Mr. Levy, my adversary in this case. He's ready to argue the motion. Because there is a big calendar from 9:30 to 12:30, we're all sitting there waiting to be heard. We're at the end of the calendar, like we are today, actually. And so here we are. At 12:30, we find out, by the way, nobody from Mr. Levy's office tells us they're seeking to close the courtroom. Nobody tells us anything about closing the courtroom. At 12:30, Judge Knock announces that he got this call the day before to close the courtroom. We don't know anything about it. I spent the night arguing, getting ready to argue the motion, and now it's 12:30, and I find out that somebody wants to seal the courtroom. And what does Judge Knock do? Judge Knock asks, the courtroom is now almost empty because we had a 3-hour calendar that was read before our case came up. Judge Knock asks the court, is anybody in the court that shouldn't be here on this case? As it turns out, a colleague of mine, not in the matrimonial bar, but in another bar, heard about this motion, and I don't know how he did, and he asked me if we were arguing it, and I said yes, and he's a friend of mine. He said, do you mind if I come? I said no. Judge Knock announces to the court, is there anybody here who is not on the case? And this colleague, friend of mine, a lawyer, says, I am. He says, you're out of here, and he immediately throws him out. No motion, no order, he throws him out of the court. He said then, is anybody from the press here? That's the next question he asked. And as it turns out, not to my knowledge, not to my firm's knowledge, we have no idea, there's somebody from Bloomberg News there. Then Judge Knock does is the reporter from the Bloomberg News goes up to the bench, off the record, it goes off the transcript, Judge Knock does, and has a conversation with the reporter. We have no idea what that conversation is. None
So
whatsoever.
your issue on appeal is that Judge Knox should not have closed the courtroom, right?
That's the issue. And so I'm getting to what happened before. He has this conversation with the Bloomberg reporter. He throws out a lawyer in the courtroom. No motion is yet made. He sets up a motion schedule. Again, nothing yet has happened on this motion. He sets up a motion schedule, and at some point directs the lawyers not to use a NICEF filing. He wants a secret filing of these papers by email, by private email, so that nobody knows about it.
You're talking about this case, right?
This case, this is what happens
So
before
is it a direct email to the judge or to?
the direct email to the judge.
And this is because of these confidential documents?
No, this is because an announcement was made the day before by an associate at Blank Rome, ex parte as it was, that they're going to make a motion for to close the courtroom.
And the purpose of you appearing for argument was on defendant's motion to dismiss. That
That's
was That was
correct.
what you were preparing for, not for closure of the courtroom.
Of course. So the next thing Judge Knock does is he directs that there be a email filing, no NICEF filing, as the court rules now require, no NICEF filing, and finally the filing is.
Sorry, what, counsel, in email filing, you mean there was no court record as a result?
No, there was a filing to the judge. There was
Right.
There was no public document made of the fact that anybody was.
So no court record.
Well, like in the old days, at some point in time, I'm sure he would file the papers in the clerk's office or something like that.
And the reality is the case law, and it's in the briefs, Judge, is you must have if you are attempting to close a courtroom, you must let the press know. And how do you let the press know? By a public filing.
Well, not only that, but, open courtrooms and the right to the proceedings observed in the proceedings is paramount. That's the other issue.
Of course.
There has to be a motion. So I want to be clear now. So there were no oral arguments. No oral arguments took place.
No, this court stayed. First, a one-judge stayed, then a full bench stayed the order of closure. And with respect to the order of closure, the constitutional cases, the New York judiciary law, you're all familiar with that law.
Right.
It requires compelling reasons.
Yeah. And the Court of Appeals just came down with 2 cases, or at least 1 case last week, but it was in a context of a criminal case. But I think it's still,
I was going to get to that.
Yeah.
Last Wednesday, the Court of Appeals came down with 2 cases reversing the appellate division and on the issue. And by the way, the fact it wasn't.
And they reversed this department also. I just want to say I happen to have been on that bench.
I didn't
and
say that, Judge.
I know. And I think the other one was a 3rd department.
But anyway,
case as well.
it's-
But the other issue was that the husband has now, he ultimately withdrew, did he not, his application for closure of the courtroom?
No. What happened was he proffered the idea that he would withdraw his request for a closure. It's not part of any record before this court. He proffered a closure. He proffered a stipulation, but the stipulation didn't say he wasn't going to do it again. It didn't say he wasn't going to get before the court, and it was still going to be open. So, and frankly, we had briefed the issue, and rather than coming back to this court again at another motion, this was a dispositive motion. If we had lost the motion, Judge Weber, and the case would be gone. There's tremendous interest in this case because of the amount of money that's involved, and because if this husband can get away with taking the preponderance of the marital assets under 236B, I think it is, all assets accumulated during the marriage. This was all accumulated during the marriage. That's the allegation here. And those are all marital assets to be distributed. If you put them in a trust and attempt to put it beyond the reach of the wife, that's the attack being made here in this
Thank you.
court.
You have time on rebuttal.
Thank you, Judge.
Good afternoon, Your Honor. Sam Levy from the law firm Blank Roan on behalf of defendant respondent John Paulson. May it please the court.
Counselor, if I may, I'm very disturbed about the notion that an attorney will call a judge and have a conversation without speaking to the adversary and having that adversary join in the conversation. You know that that's a black and white rule.
Absolutely, Your Honor, and I'm glad you brought that up because I was going to first introduce that. The record at pages 122 to 125 include an affidavit from the associate describing what actually happened, not the misrepresentations that have just been made on my adversary in this case. The night before the court, with us expecting that there may be press invited into the courtroom, it's now been alleged that the press wasn't invited by counsel, but yes, they're trying this entire case and the marital case in the press. With the expectation that that press may be in the courtroom, my associate, under my direction, contacted the part clerk to ask and inquire what the procedure may be if the press was attendant in the court to exclude the press. The part clerk asked for the index number of the case, and unbeknownst to my associate, was then transferred to Justice Knock himself.
But then, at that point, why wouldn't your associate have said,
Thanks, goodbye.
Yeah, goodbye.
I have to get off the phone and call Mr. Cohen's office. I can't speak to you.
Because
Thank you very much, Judge Knock, but I can't speak to you. Why wouldn't your associate do that?
Because Justice Knock started asking questions directly. The conversation was maybe 30 seconds long.
It doesn't really matter. I mean, I think this is not that relevant, but it doesn't really matter at that time. The associate at that point in time should have said, I really can't speak to you. Or the associate could have said, you know what, let's conference in Mr. Cohen or, an associate from Mr. Cohen's office. Better practice also, the associate probably should have contacted Mr. Cohen's office before making overtures to the court clerk. But I'm not here to give, advice on what associates should or should not do. So let's stay with the record.
Let me head down the road here. Commercial cases, a lot of stuff gets sealed under however the parties argue. But when there's oral argument, there's never been any application to close the courtroom. This case is a plenary action, right? Unless I'm mistaken, it's a plenary action.
Yes.
So why is there any basis whatsoever to close the courtroom? I mean, you have sealed documents. Yeah, you have sealed documents, but after the fact, things can be taken care of. But the closure of the courtroom. I mean, if I don't close the courtroom for Macy suing Martha Stewart, why would this case get closed?
Well,
and they got a lot of documents they had under seal. Let me try to tell you that.
Well, Justice Oing, I think you'll agree that the right of public access is not absolute. There's no place in the U.S.
Counsel,
Constitution.
It's defined by Judiciary Law Section 4, which Judge Knock never mentions, and which is pretty absolute. The sittings of every court within the state shall be public, and every citizen may freely attend the same. And then it has a very narrow definition of kinds of cases in which that's not true, and as to those, the court may in its discretion exclude people, but only as to those, and a commercial case is not one of those categories. So what possible legal basis was there for closing the courtroom?
And what I found to be most interesting was Matter of Capital Newspapers Division of Hearst versus Moynihan, which is a 1988 case, which the Court of Appeals specifically stated that closing a courtroom to public access on the grounds that the proceedings implicate documents previously under seal is something you cannot do.
Well,
and that seemed to me to be directly on point.
Well, you would eviscerate the seal by, in this case, there was a consent seal. Okay.
Counsel, that doesn't matter in a divorce. In a divorce case, everything is, all the papers are sealed, but the courtroom is open.
But this is not a divorce case.
I know it's not a divorce case, but you're saying that having an open courtroom eviscerates the seal, but that's not how much, in matrimonial cases, all of the documents are sealed, but the courtroom is open, consistent with.
Right, in the case law, the judiciary law specifically states there have to be other less onerous alternatives to closing the courtroom.
When you're talking
and at
about-
the very least, I'm sorry, there has to be some type of findings on the record as to why the courtroom is going to be closed.
You didn't even have a motion.
Well, I'm not sure which order to answer all.
I think they're all
Let me
related. You could probably just sum it.
Let me prophylactically try to address the lion's share of questions on this issue. Here, there was a seal application which pertained to confidential private.
Which case? A seal application in this case?
In the trust, I'm only speaking to the trust
Okay,
case.
not the matrimonial.
Correct. There was a
got it.
seal application in which confidential, private, non-public information and documents were contained in certain materials. What were they? The trusts themselves, divorce action affidavits, tax returns, trust assets. The underlying case involves a 3211 documentary evidence dismissal, okay, which was just before Your Honor in the last argument. They necessarily pertain to the documents. The causes of action in the appellant's complaint are involve fraud, fraudulent concealment, fraudulent conveyance, common law fraud, all of which invoke documentary evidence. The documents that were subject to the seal include, among other things, tax returns. And part of those tax returns include assets and the performance of those
Yeah, but
assets.
counsel, you're missing one point. That seal that you're talking about, in
Yes.
this case here, that was agreed to amongst the parties, right?
It was consented to.
It was consented among, you never had a judicial, because as my colleague said, if you're going to have a judicial seal or judicial order sealing the document.
No, there was an order.
Yeah, but it was after based on your consent. It wasn't that the court had to go through its own analysis as to why to seal a document, because usually one side wants to seal, the other side doesn't, and that's when we have to go through our analysis to say that all these boxes get checked for us to actually seal it, because we have to put on the record why we're sealing something, because as my colleagues pointed out, it's always not to seal anything. So the fact that you have consented, that takes the burden off of me in terms of I don't have to do the check mark, but that doesn't mean that it stays sealed forever.
Well, respectfully, the seal order from Justice Knock went through more than just an analysis. The parties consented to it.
But how does that relate to the closure of the courtroom? I think is the better issue because, okay, he sealed some documents and, there for whatever reason, even if the analysis was done on the record, how does that relate to the closure of the courtroom, which apparently it appears to be maybe made on an ex parte application?
That's a very good question, okay? And because this is a 3211 A17 documentary evidence dismissal motion, those documents themselves are necessarily implicated as part of the oral argument. You don't have to take my word for it. In Justice Knox's decision closing the courtroom, quote, he said, oral argument will inevitably discuss sealed information.
But see, counsel, the thing of it is, and I know that, you are wedded to your case, this is your case, but in the real world, it's nothing special, right? I'm just saying it's nothing special because we deal with this all the time. And the documents that you mentioned, in terms of the information as to tax returns, et cetera, these are issues that courts deal with all the time without sealing the courtroom.
Well, respectfully, this deals with more than just commercial information in tax returns. This also deals with the potential harm to the couple's children. The bases of
Adult child. But again, issues that, they deal with on the matrimonial side and issues that we deal with commercial cases all of the time. The fact remains that sealing a courtroom, or closing a courtroom should always be, your last possible option after looking at all of the other alternatives.
Well, and one of the alternatives here could be that the argument take place outside of press coverage. A transcript is then prepared and redacted, and the press has an opportunity to make a motion to unredact or limit the redactions on the transcript.
That would be great, but I think, maybe your adversary, maybe the other side should have some opportunity to weigh in on these issues, but they never had the opportunity to do so.
Well, they
And
did.
what about the
this idea was presented to them and rejected.
But what about the filing off of NICEF by direct email to the judge? Didn't that ring some bells that there was a problem here?
Well, that was not the email filing of the briefing on the closure motion was not at the invitation or suggestion of the
I don't care whose invitation it was. It seems to me that at that point you'd call your adversary and say, well, gee, we've got an odd request here. I don't think either of us should be complying with that. This is not how we do things.
Well, again, respectfully, I don't think I was in a position to reject the direction of the Justice Knock on how he preferred the briefing to be filed. But
How
more.
far does that go? Anything a judge says you would do?
No, of course not. But more important.
He told you to jump off the bridge. You're going to jump off the bridge. It's Judge Freeman. Thank you. You have
well,
time.
just if I may.
But I do want to know, where are we now? Because the appeal does not deal with the filings offline, et cetera. It's only dealing with the closure. But where are we in terms of the filing offline? Where are the proceedings at now before Judge Knock?
Justice Knock issued a decision based upon the email briefing, a public decision, okay? The press is not here today on an amicus. The press was informed, and Bloomberg was informed about this briefing. Bloomberg was in the courtroom, and the next day, Bloomberg published an article saying that there was going to be briefing on the issue of closing the courtroom, and the transcript was published. So to the extent that this panel is concerned that the press did not have an opportunity to be heard on this issue, it was heard on the day that the closure issue was first addressed. It reported on the briefing of the issue. There was a decision on it, and the parties are here today on an appeal, all of which has been public, and the press has not taken the opportunity to intervene, signaling, I believe, that the press has no interest in being heard on this issue. So the side and collateral argument that the briefing was ordered by Justice Knock to be done by email, I think has no bearing on the issue in this case about the extent to which the court, in this limited context on a dismissal motion concerning documentary evidence, should agree to honor the sealed documents consented to by both parties only on this limited issue for the dismissal motion.
So you're
Have
asking.
you still given us any support as a matter of law for doing that? I read you Judiciary Law Section 4. That says you're wrong. Is there anything that supports what you're saying?
Well,
and Justice Weber read the cited to the 1988 Court of Appeals case. What supports your position?
the Court of Appeal cases dealt with criminal trials. All the decisions in the
Capitalhurst Division, Capital Newspapers versus Moynihan was not a criminal case.
No, I'm talking about the cases that were raised in the briefing by appellant dealt with trials in this case. We're dealing with a limited dismissal motion of 3211.
Yeah, I don't think it matters because I think the judiciary law talks about.
We have to. You're asking us to decide.
Yeah, it says, but I believe it says proceedings. But anyhow,
It says sealed documents, open courtroom. You're asking us to pick sealed documents over open courtroom.
yeah.
No, I'm actually asking you respectfully to honor both. You could close the courtroom for this argument only, and then issue it, and then the
But you
transcript.
have not told us any legal basis for supporting your claim that the courtroom should be closed, apart from the fact that you think that when there are sealed documents, you should be able to close the courtroom whenever you ask the judge for it. What legal basis for it? What precedent is there for the request that you're making?
Both in decisions of this department and your Court of Appeals, under limited circumstances, there are cases in which courts are closed in particular circumstances, which we have cited numerous ones in our more than 40-page briefing.
Thank you.
I'll be very brief. Judiciary law provides that in all sittings of the court, that's motions, and we've cited a number of cases in which motions must be kept open. All sittings, the judiciary law has never been abridged on that ruling. The idea that the children in this case are 21 or 22, or 18 or 19. One is a sophomore at Harvard, the other is going to Harvard, that these children will somehow be affected by this publicity. It's kind of interesting. The wife found out about this case because Mr. Paulson's then lawyers and Mr. Paulson gave a quote to the Daily Post that they were, page 6 of the Post, that they were getting divorced. That's how my client learned of the divorce, the publicity. The day after they made a motion for a closed trial, Mr. Paulson announced that he gave $100 million to a university. That he had a $500 million trade that he had just accomplished, and he made money. The publicity on this case is all, yet he closes a courtroom, as Judge Gesmer pointed out, without any precedential value, and Judge Knock bought it. Thank you very much.
Thank you. Thank you both.
Thank you. Have a nice evening.
Good try.